May it please your lordship.
Please, your lordship. My lord, I pay for listing of new tender method for Wednesday, my lord. Motion method. Deeply obliged.
May it please your lordship. I beg to mention item number 35 of today's list, my lord. Item 35 of today's list, my lord. In this matter, Junior Government Advocate S. Sharma is supposed to file some affidavit, my lord, as she has received instruction, but all of a sudden she has to go to Calcutta for some medical urgency, my lord. Can be accommodated till Friday, my lord.
The request to the learned counsel.
I have informed the other.
Huh?
I have also informed the other.
You have for a respondent?
Yes, ma'am.
For the respondent matter sent it on to be listed after 3 weeks.
May it please your lordship. I beg to plead for listing this matter, lordship.
Which one?
It's a new repeat, lordship. The matter pertains to the attachment order issued by the recovery officer of the EPFO, lordship. And there is a settlement agreement between my petitioner and the EPFO.
Wednesday?
Highly
Request item number 37. With the consent of the petitioner, my lord, that will be taken out 29th, my lord. In the meantime, I will file my affidavit.
What is this matter about?
Relating to water, Jal Board, my lord, supply of water.
Oh, that matter.
That one, better one. I will file my affidavit. In the meantime, on 16th year, they have filed an additional affidavit. I have to go through it all.
Who has filed?
My petitioner has filed additional affidavit.
You have informed the other side?
Yes, yes, ma'am. Please.
Okay, when do you want it?
On 29th, ma'am.
Take it. Take it up for final disposal on 30th. 30.
30.
30. Systematic. The request of the learned counsel for the respondent. GMDA.
Not the Jal Board, madam.
Jal Board. Matter sent to John. We listed on 31, 2024.
May I appear? But I beg to mention for matter for order for.
Order?
On
why?
Because the matter pertains to, my lord, with regard to construction of, my lord, IAY house. Petitioner's house has been given to somebody else, my lord, and therefore no construction has been effected.
Why do you need it for orders?
Because, my lord, steps were taken, my lord, the report has come. Therefore, it will come under order.
For admission?
If your lordship is
When?
On any day next week.
Nothing. We'll have it on 5th of February.
I'm obliged. My lord, I beg to mention item number 28, my
Hmm?
28, my lord.
28, yes. Why?
Lord, maybe my lord taken up as upgraded matter, my lord. As because my lord, in several occasions I could not do the matter. I'm on pressure, my lord. My lord, it may be taken just after motion matter.
Today?
Today, my
Okay.
after motion.
Very good.
Yes. The contemporary the claim was that the reputation for payment of outstanding amount. Large number of cases were decided, and partly it has been implemented, and partly implemented. Part payment has been for the entire so that is
Mr. Chaudhary, tell me one thing. When do you file a contempt? You file a contempt when you give an opportunity to the other side, and the other side willfully violates.
true. You're right. But then here is a case where my lord, the large number of cases were decided part that was been.
Understood, but unless you have shown anything, any document out here to the effect that you have submitted this
Yes, I understand.
then
but I have made a statement that
no, statement would not do, because here is a case of issuance of a notice of contempt. So this court would not do so unless and until you bring on record any document to show that you have submitted this document, this judgment to the authorities concerned. Yes. Mr. M.K. Chaudhary, the learned senior counsel, submits that the petitioner may be permitted to withdraw the instant petition and refile instant contempt application and refile after intimating the concerned authorities for implementation of the judgment and order dated 27/9/2022, passed in deputation number 4329/2019. So, the instant contempt application accordingly stands closed. However, the petitioner is given the liberty subject to the compliance.
It's a matter where the fair dealer of fair price super report to your number 10. What happened, my lord? An FIR was lost, but to my lord,
Mr. J.M.A. Chaudhary, tell me one thing. Everybody has a different cause of action.
out of the same order, my lord.
Are you not, everybody has not been issued a particular notice
Suppose notice separate.
separately? Everybody has submitted a reply?
Yes.
And then how can you join everybody's cause of action by way of a one single petition? Yes, in certain cases you can
Yes.
by paying the court fee, but here it is absolutely a separate cause of action. Everybody has a separate right.
The allegation made is my lord, suspension order, lord, kindly see, and the checked order, my lord, page 66 and it's 5. And we didn't receive, my lord, the suspension order. That is my also case, my lord. I have also alleged we didn't receive the copy of the suspension order. Suspension order was never sent to us, furnished to us. By this compound order,
It is only temporarily take because
Take,
you have
no?
been suspended.
yes, my lord, suspension order was not supplied to us. That is my case.
No,
We are
but
not in a
but-
position.
are these not orders being passed out here to the any effect? Has there any order being passed
No, my lord.
for cancellation?
No, my lord, nothing.
Then what are you challenging?
My lord, we are challenging, my lord, in terms of the provision of section 15 of the Assam Public Distribution Act, my lord. They are supposed to propose us, they are supposed to suspend us, and copy of suspension order must be communicated to us, my lord. And thereafter, a proposed notice, if it is not supplied to us within 90 days of the suspension, my lord, they cannot continue with the, my lord, suspension order. That is our case, but suspension order was never communicated to us.
No, anyways, when were your
mention was
notice being
made.
issued?
My lord,
9/3/2022.
22/12/2022 tag order was there, my lord.
Yeah.
So far as
20
second paragraph is
No,
concerned, my
it's
lord.
okay. And you have submitted your reply.
Yes. And my lord, only if they furnish us a copy of suspension order, we can find out whatsoever.
Yes, who is appearing for the government?
We have to take instruction. We have to take instruction of the petitioner.
Understood, but what? But how can you continue suspension
Yes, my lord.
beyond 15 to?
Nine.
Because 15 said that you can only suspend for 90 days.
Yes.
And thereupon, if you want to extend, you have to again issue a show cause as to why the suspension should not be extended.
My lord. Yes.
That has not
The
been done.
provision, yes.
Now, on one hand, you have issued them the show cause notice for cancellation on 9/3/2022. They submitted a reply on 12/3/2022. And we are in 2024. You want to just complete it by 12/3/2024. But yes, does it take 2 years for you to do that?
Otherwise, they have to complete it within time.
Then
With that observation that direction might it may be. closed.
absolutely no. We'll issue notice. Quick notice 29.
Right.
Issue notice making it returnable on 29/1/2024. Ms. M. Borman appears on behalf of the respondent number 1, 2, 3,
Up to 5.
5. No, 4 and 5.
1 to 5 I may pay.
1 to 5. And Mr. G. Bodler appears for respondent number 6. Why you are making 7?
7, my lord. The allegation is against the seven, my lord, that he has misappropriated the PDS item. With that reference,
As the respondent number 1 to 6 are duly represented by the council, the extra copies of the petition be served upon them during the course of the day. As regards the respondent number 7, the petitioner is directed to take steps during the course of the day by way of registered as well as usual. Further to that, the petitioner is also directed to take steps by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date upon the respondent number 7. The case of the petitioners herein is that on the basis of some report, the fair price shops of the petitioners have been tagged with certain other fair price shops without even issuance of any suspension order. The petitioner, it is the further case of the petitioners that on 9/3/2022, the petitioners have been issued respective show cause notices, and the petitioners have also submitted their reply on 12/3/2022. However, the respondent authorities have neither taken any steps in that regard, and the petitioners' fair price shops for which the petitioner have not been able to operate their fair price shop. The respondents, more particularly the respondent number 1 to 5, shall obtain an instruction and apprise this court on the next date as to why the show cause proceedings have not yet culminated or decided till date.
blame.
Number 3.
Yeah,
Hmm.
regarding contractual payment method,
Hmm.
the efficient work
Why did you wake up so late?
method. We have represented on many occasions.
What?
We have submitted representation on many occasions. but-
Fantastic.
but-
Last representation submitted in 2017.
Yes, my lord.
Then
Thereafter, my lord,
thereafter what?
in 2021 also we have my
Show
lord,
me a 2021 document out here.
right, in this case, it's not, but in other cases, my lord,
Other cases?
some other cases,
Some other cases, is it linked?
my lord, item 4 and 5,
I understand. Item 4 and 5 is different.
my lord, but in
Why didn't you join like Mr. JMA Chaudhary has done? Tagged everybody's matter together.
in this matter, my lord, 10
Then last
But
is
they-
2017.
they have
We
approved,
are in 2024.
they have approved, my lord,
When?
recently approved, my lord,
When?
but no representation was filed.
Understood. Recently approved when? Have you written?
I have stated that.
Where?
Lord, the demands were submitted by the executive chairman. I have stated my paragraph.
When?
The opponent also had
That
admitted,
was in 2016-17.
but remained unpaid money, issuing letters to government demanding funds for the outstanding. But they have not taken any steps.
Mr. Counsel, who drafted the writ petition? You. So you must be knowing where. Not a single statement made. The learned counsel appearing on behalf of the petitioner submits that he will file an additional affidavit bringing on record as to why there has been a delay in approaching the court after 7 years. This is the matter of 2 weeks.
Item on 1/3/21, my lord, they have served a notice.
Then you have issued a section 18 notice. Why don't you go to the civil court?
No reply was.
What? This is a tender for which year? 2012.
12, sir.
Then we are in 2024.
But no reply was.
Mr. Das, what is it? You have a very golden line put out there in the work order. Payment will be made as per availability of fund and the claim compensation including interest shall not be entertained for delay. Huh? We dispose it of 6 months. Verify and pay.
But if it is FM flood management program, then it will, if the scheme is under flood management program,
Hmm.
then it will take some time because the central there is yet to be received.
This is the flood management, then the
No.
central government has to be made a party. Have you
Yes,
made a party?
No, I don't know. I have to query it. I think
No, but how can you do this for such a long time? 12 years, 10 years.
Lordship,
Why did you take their work if you don't have the money?
we are taking
Water
the work.
Resource Department is fantastic. They take somebody's land and then they think that, okay, we will someday acquire. This is the state of affairs. Why?
This is, I have taken instructions, Lordship, regarding this bill.
Okay. Issue notice making it returnable on 12th of January, 12th of February 2024. Mr. R.M. Das appears on behalf of
1 to 5.
the respondent numbers 1, 2, 4, 5. Mr. Arbo Pujari appears for respondent number 6. As the respondents 1 to 6 are duly represented, extra copies of the writ petition be filed during the course of the day. The case of the petitioner herein is that the petitioner is entitled to an amount of rupees 44,598 from the respondent authorities. However, no payment has been made in spite of the work being completed. The respondent shall apprise this court on the next returnable date as to why the said amount has not been paid.
Five or eight, 5, 6, 8, and 9.
Yeah.
Plus, amounts are different.
You give a piece of paper, put the amount against item number, give it to him, so he shall communicate to him, and the order will be there.
For 7,
Engage down the legs and another
Who is on legs?
in court number 26. Item number 7.
No, we issue notice, same
Lordship,
thing.
Lordship, yes.
You find out. Issue notice making it same order the DD and he represents 1 to Mr.
All-
S.R. Borua represents 1
all-
to 6.
All right.
Extra copies, next date, same date. Good.
Thank you.
Amount to yeah.
12 to.
Order to incorporate. The case of the petitioner herein is that the petitioner had duly supplied his vehicle for the purpose of the petitioner's vehicle was the case of the petitioner herein is that the petitioner's vehicle was requisitioned by the respondent authority. And in that regard, the petitioner had duly submitted a bill amounting to rupees 4,13,992. However, in spite of various representations, the said amount has not been paid, for which the instant petition has been filed. The respondent shall apprise this court on the returnable date as to why the petitioner's amount has not been paid.
highly obliged.
Yes, Mr. NNB Chaudhary.
My lord, matter is related to my lord settlement of the fishery, my lord. Earlier, my lord, Ojabora Meen Mahal was settled with the petitioner, my lord, for the period of 2022 to 2024, my lord. Period from 1/7/2022 to 30/7/2024 by Missing Autonomous Council, my lord. Because it was all under the jurisdiction of Missing Autonomous Council, my lord. I
Then,
have deposited the kiss money, my lord.
very well.
My lord, subsequently, what happened, my lord? And tender was issued by the, my lord, fishery department, my lord, for settlement of the, my lord, the Mahal, my lord. That Mahal name is, my lord. That Mahal name is, my lord. Uh, uh, that Mahal name is, my lord. Koroimari Kopoto Property Fishery Society, my lord. Settled with the Koroimari Kopoto Fishery Society, my lord. Of Koroimari Meel Mahal, my lord. And my lord, your lordship kindly come to page 35, my lord. That is the tender, my lord. And what happened, my lord, subsequently, my lord, an order has been passed by the, my lord, Circle Officer, Gorpur Revenue Circle, my lord, that Sarituar Koroibil Meen Mahal is settled with Korokori Kopoto, my lord, page 37, my lord. And so who was the, my lord, settlement holder of, my lord, Ojabora Meen Mahal, my lord, directed to evict that, my lord, Mahal within the period of 3 days. Subsequently, although he has passed an order, my lord, but my instruction that we are still in that Mahal, my lord. How can, my lord, a Mahal has been settled with the petitioner by Missing Autonomous 2022 to 2024, my lord, can be, my lord, again settled with, my lord, Koroibari Meen Mahal, my lord, without demarcating the boundary of the fishery, my lord. They are not discussed with them, whether they are discussed with the Missing Autonomous Council, my lord. Nothing has been discussed, my lord, that has been done, my lord.
Yes, Mr. Sharma.
The Missing Autonomous Council it has no authority to settle the fishery lot. They are not take schedule lot. So now the State Department is out. But I will give it a written instruction to be better lot.
What is this Mahal business? This Mahal is a government Mahal, 60%.
Yes, sir.
Huh?
Yes, sir.
Then why did the Missing Autonomous Council?
They are also in almost many fisheries there.
Huh?
They used to settle in many cases.
I am coming, my lord, one thing, my lord.
There are many cases lot where Missing Autonomous Council sending on
Who is paying for the Missing Autonomous Council?
Antonu Gotakor, as Gotakor.
Where is he?
Written instruction will be better on for me though. But here they Missing Autonomous not without being not fixed schedule.
Your lordship kindly come to Missing Autonomous Council Act. Action of the- Your lordship kindly do it,
Copy,
section
sir.
18, my lord.
They have not
Okay.
copied to the Missing Autonomous Council. Name not shown.
Yeah,
Missing Autonomous Council copy not served.
okay, sir.
Oh, okay, this one.
No, name not.
No. Not given.
Only one. Lordship, they pick the-
Mr. NNB Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that he would serve a copy to Mr. L. Kotaku, the learned standing counsel of the Missing Autonomous Council, and thereupon, during the course of the day, this the matter again on the matter again on 25th of January, showing the name of Mr. S. Kotaku, standing counsel of the meeting. Yes,
Non-payment of the contractual bill shortly for the Panchayat election, Dalbari district. The lordship turns to annexed page 14 is the bill, and page 15
where is
is the-
PNRD? No PNRD council.
Lordship,
will have
page
issue notice making it returnable on 16th of February 2024. Mr. S.R. Borua appears on behalf of the respondent number 1
and 4.
4. None appears on behalf of the PNRD department on call. As the respondent, Mr. A. Todi, the learned counsel appearing on behalf of the petitioner duly submits that they are standing counsels appointed for the PNRD department, and he may be given liberty to serve extra copy, serve copies upon the said standing counsel, taking into account above the taking into account the above, the petitioner herein is directed to serve extra copies of the writ petition to Mr. S.R. Borua, representing the respondent number 1 and 4, and as regards and to Mr. N.K. Devnath, the standing counsel of the PNRD department, in respect to the respondent numbers 1, 3, and 4. Na? You
The 3 Lordship, I think, are to pay. He's Assam State Election Commission.
you serve copies upon them.
Already, sir. His name not shown, I guess.
Him not. To an issue notice making it returnable by 16th of February 2024. Mr. S.R. Borua appears for respondent number 1 and 4. None appears on behalf of the State Election Commission as well as for the PNRD. It has been stated at the bar that there he Mr. N.K. Devnath appears on behalf of the respondent number 2 and 5. None appears for respondent number 3. Huh? 2 and 5. As the respondent numbers 1, 2, 4, and 5 are duly represented, extra copies of the writ petition be served upon them by 24/1/2024. As regards the respondent number 3, the petitioner is directed to take steps by way of registered as well as usual.
Lordship, please standing out there.
The petitioner by registered as well as usual. The case of the petitioner herein is that the petitioner was granted a work order for completion of certain work which the petitioner had duly completed. However, the respondent authorities have not paid the said amount for which the incident petition has been filed. The respondent shall apprise this court on the returnable date as to why the petitioner had not been paid the said amount. Same
But
amount to complete. Yes, non-payment.
Yes, sir. Yes, Lord.
You are appearing for whom?
PWD.
H. Sharma appears for the respondent number.
114.
Who appears for 123?
120, I am appearing.
Tessa Borua for 120.
4, 5,
Sharma appears for 4 to 7. Extra copies by Gento, copies X, returnable on 16. The case of the petitioner herein is that the petitioner was allotted a work for construction of hostel for inmates, office building, grade 4 quarters, and brick boundary work of destitute home, Ighal Tari at Dhubri in the year 2018-19. It is a claim of the petitioner that he had duly completed the work However, his final bill, which was submitted on 31/8/2022, have not been released in spite of various representations for which the petitioner has approached this court. The respondent shall apprise this court on the returnable date as to why the petitioner have not been paid his due entitlement.
I plead your lordship.
Hmm.
Lordship, I am aggrieved by the order dated 8/1. I'm aggrieved by the order dated 8/1/2020, wherein my
You are still suspended.
Yes, your lordship. My license is suspended, your lordship.
Who is appearing for the respondents here?
Lord.
It is similar case to the item number 2 or 3, where she had appeared. Here is a case where you have kept his, what do you call,
My fair price.
PDS license, PDS fair price shop under suspension. Neither you have taken any decision on the show cause proceeding.
No communication has been made here.
Issue
Lordship,
notice, we have it on 29.
29. In
Issue
item
notice making it returnable on 29/1/2024. Mr. M. Burman appears on behalf of the respondent number 1, 2, 3, 4, 5, and 6. Appears on behalf of all the respondents.
All the-
Extra copies of the petition be served during the course of the day. The case of the petitioner herein is that the petitioner fair price shop was suspended on 8/1/2020. Thereupon, the petitioner was issued a show cause notice on 27/1/2020. And the petitioner duly submitted his reply. The petitioner had not been intimated as regards the fate of the said show cause proceeding. However, the respondent authorities have continued to keep the petitioner's fair price shop under suspension, which is in violation to clause 15 of the Assam distribution of, what is the name? Assam Public
Public
Distribution Order 1982. The respondent shall apprise this court on the returnable date as to why, as to what is the status pertaining to the show cause proceedings initiated against the petitioner, and further to that, the respondent shall also apprise this court as to whether the petitioner's fair price shop could be kept under suspension beyond the period of 90 days without issuance of the mandatory notice in terms with clause 15(2) of the order of 1982.
15.
Yes,
Able Lord. My lord, here the case the my lord the pretty much Nagaon Eastern NIT for settlement of for 7 years. My lord, the last date was 21 9/2023. As a 60% teacher, my lord, the pretty much has no right to.
you are the
cancel.
highest
Yes, my lord.
and they've cancelled it.
My lord, the first bidder was defective and sixth bidder was defective. My last part often I statement my lord, but
Petitioner was the highest
yes, my lord, valid bidder.
and they cancelled it.
No cancellment. My all tender process is cancelled.
That is what I'm saying.
Yes.
They have cancelled the tender process.
Tender process, my lord.
And now they are initiating a fresh one.
Tender.
Have they issued it?
Yes, my lord.
You have participated.
No, my lord.
Participate.
Why, sir, my lord? I am the high bidder. Without they have no authority, my lord. They cancel, my lord. All the tenders was without information or the regions, my lord. Nothing, my lord.
No, you without prejudice to the petition, you participate. We'll see on the next date what is their act, why they have gone for.
That
Why should we stall a particular proceedings?
No, my lord. I'm not. But there is a
No, if this court grants a state day on the entire process, the
But
fishery
my
mahal,
work
who is running the
my lord,
fishery?
all the tender was secured.
Understood,
basis of
Mr.
tender, they set up
Mr.
another-
Counsel, I have understood. The question is, if I stay the entire process as of now, you participate without you participate, but we'll ask them. And if the tender process out there, if they don't assign any reasons for that, then we'll strike off this one. I think that is the best way. And otherwise, because otherwise the fish mahal will be without, who will be catching the fish?
Last 5 months, they were run by the third party man.
Third party. So
So
if I stay, then the third party will be more benefited than you.
My humble submission, they asked for NIT dated 1/9/2023. On the basis of this NIT, my lord, it may be settled, my lord. It refer to the government, my lord. And without any cost, my lord.
But can that be done today? No. Yes, Mr. Sharma, what is this
Lordship,
arbitrariness on your part?
Lordship, not our part. This is part. Lordship.
Yeah,
This is
DC.
in a similar case, Lordship.
Yeah.
In a
What-
similar,
what
in
has
a same
happened?
fishery, Lordship.
Then,
Actually, DC has acted without authority, Lord.
oh, very well. Then we set aside that.
This is the order, last day order. Actually, DC was supposed to transfer all the tender documents without making a decision to the government, Lord. So we are. Same fishery. He has acted our part, Lord.
No, this is a different matter.
The same, it's arising out of same fishery. Lord.
Them, but the difference is the difference, man.
Difference is the different, not here, Lordship. He was debarred from participating in the next tender, Lordship. So in that case, court has observed this part, Lordship. Last part, Lordship.
So this is the person who had participated and was the third highest.
Yes,
Yes,
ma'am.
You are?
I'm the highest bidder.
Then why did they have not contacted you and have asked the third highest bidder to give more amount?
No, not me, Lordship. DC.
Huh?
It is a DC, Lordship.
Yes, what is the DC's power? Does the DC have the power?
In Lordship, in that 60% fishery. Ultimately, decision has to be taken by the government, Lord.
No, does the DC
But-
have the power to cancel? Because the issuance is always by the deputy commissioner. Who has issued the NIT? Initial NIT?
Deputy Commissioner.
Ah. So if he can issue, can't he cancel? Then you don't have a case.
DC can man issue a part, settlement part is not right, but
No, he has cancelled the tender process. He has issued and he cancelled the tender process. The question is, Mr. Sharma is submitting that the DC cannot cancel.
No, no, I'm not. DC cannot take decision, Lord.
Now,
They
if
have
not-
taken. He has taken the decision, Lord.
To cancel it.
No, no, he has the Lordship. There is an order. Lordship, there is an order, Lordship. He has taken a decision. But that we haven't. So I don't want to say in it. We have initiated. Department has initiated that. Part. Thank you. Order to be an. He has not annexed all the documents, Lordship. In the earlier petition, we got it, Lordship. He has taken a decision, Lordship. But that decision he cannot take. He has to transfer all the processes are under rule 12, Lordship, fishery rules, Lordship. He has to transmit all the tender documents, tender minutes to the government. Government will take a decision.
No, that is for the tender finalization.
Yes, Lord.
I'm not on that. If DC can issue
Yes.
the tender, can't he cancel it
No,
in
no.
view of rule
Yes,
section 21?
he can, Lordship. I'm not disputing that. Here in this case, Lordship, he has not annexed that order, Lordship. In this case, Lordship, what DC has done, DC has taken a decision, final decision.
What is it?
That here I don't have the order in earlier petition I got it, Lordship. Here DC has taken a decision that he cannot, he is not, he thinks that the tender process he has not given so and so this way he was given, Lordship. Here I think
Because his case is not that. His case, he's the highest bidder. And the DC, whatever he has done, he has cancelled it. That is his case. So how will this case be similar with that case? That case was a case where that 10%, he was asked, the third highest bidder was asked to give more than 10%, which the third highest bidder was not aggrieved,
Lordship.
for which the DC wanted to confiscate and forfeiture proceedings to be initiated. And that is what has been stated. Kindly see the order.
In the item number 7, I have the order, Lordship. This order.
Which 7?
In this repetition, in this cause list, Lordship. 17, Lordship. I have the this order. I'm referring, Lordship. 20.
So this has been stated.
Last part is being stated.
The last portion has been stated.
Lordship. Here, our fishery
That he
department.
shall not be allowed to participate,
Yes,
that person,
that
Pramod Das.
Yes.
And that is what I see from this order.
Yes, Lord.
This is by whom? This one. This order is in respect to this.
Yes, Lord.
No, that is the reason why.
Lordship. Reason is that
But Mr. Counsel, without assailing this order, how are you maintaining your writ petition? This order of 3012, isn't it?
yes, Lord.
You can't maintain this writ petition without this or challenging this order. Because you will have a difficult because there are reasons. It is not that they don't have the reason for that. Your basic case out here is, look here, I am the highest bidder. And as such, I am the highest bidder and the DC has arbitrarily, without any reasons, done it. This is the reason. Rightly or wrongly, there is
Yes.
some reason out there. Let us see the fishery rules that it stipulates. What is the power of the government? The government's power is for settlement.
Yes.
But can't this be cancelled by the DC?
No.
Why?
DC has to refer all with all the minutes and everything to the government.
Show me.
Order
Where is it?
rule 12, I think, Lordship.
Where?
12.
Yes, Rule 12, what does it say?
My lord.
For the purpose of this rule, 60% means so and so. What does it say?
My lord, they provide that the government shall be settled a 60% of category fishery with special category of the cooperative society, non-government organization.
Understood. This is only for the purpose of settlement.
Yes, sir.
But what about the cancellation? The cancellation, if a authority issues a tender, wouldn't that authority have the right to cancel it also? If you apply 21. The DC cannot settle it. It is for the government who can settle it.
Yes,
There's
that's
no
right.
quarrel with that proposition. But here the government, DC didn't settle it. What the DC did, DC says that it is in violation of the Assam fishery rules, as he had not, there were arbitrary rates for which we have set aside this particular tender and a fresh tender will be issued.
Dear Lord,
Then
our contention, our department's contention is that, Lordship. Here, DC cannot take the decision regarding the settlement, Lordship. Here,
Understood, but has the decision taken any decision as regards settlement? No. He has said that he will, what is the,
how can it here, Lordship? Here, DC has the very minimum tender rate was fixed and so for first year. And he has the, as per Rule 48(3) of Assam Fisheries Act, the bidders quote a differential and arbitrary annual rates for different years. By this way, he is intruding to the settlement part of the department.
no. I would have understood. If he grants a settlement, it would have been different. But he has only set aside the tender process and said that we are going to have a fresh one because the person who had quoted earlier, he had quoted arbitrary rates for which it is not possible.
But if he takes that decision, does not it mean that they are intruding our right, Lordship, Fisheries Department settlement right, DC, by intruding that part that
Then why you do not call for the tender? If you are so happy with your power, exercise your power. How did you give it to the DC? What is the basis on which the DC exercises the power?
we give it. We
How?
are right. This is we have communicated to the DC for issuing a tender notice. For
So,
that,
The moment you give him the power to do so, the DC cannot settle. There's no quarrel with that. But the DC, if it finds that there is some illegalities committed, the DC has cancelled it and have gone for a fresh tender. So what is wrong with that? You don't have officials to issue tender. You have the DFDO. Do
Yes.
that. Take his help. And you cannot do anything unless you challenge 3012. Your basic reason is that without any reason, rhyme or reason, the DC has cancelled. That's your case. The rhyme or reason is very much there. That is the order of 3012. And without looking into it, you have filed it. Withdraw liberty and file properly if you want so. But this cannot be there because the reason is very much there. And without setting aside that reason, can this court allow you or give it to you? Not possible. The other case has a relevance for the other purpose, not for this, as to whether the deputy commissioner would have the power to go for forfeiture.
yes.
Because the power is the delegated power only for issuance of a tender.
Right.
It is a different thing that the tender can very well be recalled or cancelled. But tender, any action beyond that cannot be taken.
Yes.
So that is another aspect of the matter which can be very well dealt with in the other. But here is a case without 3012, you don't have no case. What do you want? The dismissal?
I liberty to turn.
Mr. Learned Counsel appearing on behalf of the petitioner submits that the order dated 3012, na?
Yes, Lordship, 3012.
30/12/2023, which is the basis for which the fresh tender was issued, having not been assailed, he would like to withdraw the instant petition with a liberty to refile by assailing the said order, including the fresh tender process. So taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the petitioner to file a fresh.
Lordship, may I pray, Lordship, on 17 is also similar, Lordship.
No, it is not. Let's see when the 17th comes. You are in a hurry?
No, Lord,
Okay, then take it.
oblige, Lordship.
Wait, this writ petition matter, they tell the circular of 14th November 2023 matter, whereby matter certain radical changes were brought into the catering policy matter, which was executed prior to
Which one? Where is the policy?
Well, the impune policy starts at 48. Before your lordships come to the policy, just the submissions I want to make now.
Hmm.
The petitioners, my lord, are railway catering contractors. They are M-panel contractors, my lord. What happens, my lord, under the Indian Railways, there is a M-panel list of contractors, my lord, which list is updated, published on the basis of their experience, their net worth, and annual turnover. Now, it is that pool, my lord, from that pool who participates in the tender process. That your lordships will find at page 72, 73.
Hmm.
But, my lord, now what has happened is, by the impune policy, they have, my lord, brought in, my lord, certain stringent terms and conditions,
Hmm.
which, my lord, excludes, my lord, I'll make that quote, my lord, excludes a considerable number, leaving only 6 bidders in the fray. And out of those 6, only 4 are from one group and 2 others are there.
Group.
Yes, one particular group. My lord, the submission is this, my lord. These are not only arbitrary conditions, my lord.
Hmm.
It promotes, my lord, monopoly. It, my lord, suffers from, my lord, manifest arbitrariness. And of course, discriminatory. Now, let's please see the tender conditions. First, my lord, please have page 72. That's the pool, my lord, of 73. Sorry, annexure E.
Hmm.
The lordships will see, my lord, details at the top, my lord, details of M-panel parties for limited tender on board services 7/11/2023. So, this is a list which continues for 1 year, my lord. They keep updating. Now, my lord, GTV as the first category, my lord, which is Vande Bharat,
Hmm.
Gatiman Tejas.
Hmm.
RSD is, my lord, Rajdhani Shatabdi Duronto. M1, M2, M3. Now, my lord, please see the list. These are, my lord, the list of 62. So this is this identified pool, my lord, which participates in the tender. It is not, my lord, that it's open to all. Now, out of this 62, my lord, the
Yes.
ones who qualify, my lord, are 5, 7, 9, 12, 14, and 15. Of which, my lord,
Your name is here.
yes, my lord, I'm number 33, Rathod.
Yes.
Then, my lord, number 2 and 3, my lord, they are part of the association. And I'll just give, there are a total of 20 members of petitioner number 3 who are part of this list.
Mobile Caterer Welfare Association.
Yes, madam. This is a registered association, madam, having out of which 20 members are M-panel members of this group, madam.
Okay.
And the petitioner number 1, madam, is the serial number 33. So this will,
And what is 2 and 3 are members of
yes,
this?
2, 3, 4, 13. Serial number 2, madam, 3, 4, 13, 16, 20, 23, 25, 26, 32, 33, 34, 35, then 42, 43, then 52, 55, 60, 61, 62. These are, my lord, the
Members of the
they are, my
petition.
lord, these M-panel contractors, my lord, who can participate in the limited tenders. Now, my lord, please see, my lord, what the impugned policy does, my lord, at page 48.
Hmm.
I'm quite conscious, my lord, of the limited scope of judicial review. Your lordships will interfere if it is manifestly arbitrary, discriminatory, my lord, or it creates a monopoly. So please see, my lord, the objective of the policy, my lord. I think your lordships need to read it, my lord. From the experience gained during the past few years with the implementation of the catering policy 2017, it has been necessitated that state-of-the-art base station infrastructure, adequate logistics and service infrastructure, deployment of qualified and skilled manpower to handle food production and services have to be put in place, not only at originating, but also at en route station to ensure service of good quality and hygienic food to passengers on train. Hence, it is imperative that an experienced professional agency is vested with full accountability of production of bills and services on board under IRCTC's direct supervision monitoring by shared operation. Objective is laudable, my lord. We have no objections to that. Now, please see, my lord, 3.2. The first change which brings in, my lord, is clause 3.2. It starts, my lord, clustering of trains.
So this empanelment,
Yes,
which was done on
11.
7/11/2023.
23.
prior to the policy.
Yes, ma'am. But my lord, it is not their case that they have done away with this empanelment. It is not their case that now they have identified this number of empaneled caterers who can now participate. This is valid for a year, my lord. And this is on the basis of experience, net worth, and annual turnover. Now, my lord, now please see 3.2, my lord, is the clustering of trains. All trains shall be mapped with service locations, and accordingly, base kitchen shall be designated for pickup and supply of milk, depending upon service requirements. Route-wise cluster of trains and base kitchens shall accordingly be formed in consultation with the zonal railways before invitation to bid. To consider adequate volume and economies of scale, award of contract shall be done for a cluster of trains and the base kitchen packed with a cluster instead of an individual train. So now there will be a cluster of trains when one has to bid for a cluster of 6 or maybe 10 trains together instead of one single train which was earlier happening. So please see 3.2. Cluster of trains and base stations shall be formed in the following two groups. Cluster A includes premium prepaid trains and mail express trains with pantry cars. In one cluster of premium prepaid and mail express trains, if the total number of trains in the cluster is up to 5 pairs, then the cluster should contain one premium prepaid train along with mail express trains. If the cluster contains 6 to 10 pairs of trains, then it should have a maximum of 2 premium prepaid trains. Similarly, cluster B includes mail express trains with pantry cars and TSB trains. TSB is train type vending, cluster of up to 10 pairs of trains. In one cluster of mail express train with pantry car and TSB trains, the total number of trains in a cluster is up to 5 pairs, then the cluster should contain minimum of 1 pair and a maximum of 50% of the cluster of mail express with pantry car trains. If a cluster contains 6 to 10, then it should have minimum 2 pairs. Please see 3.3.1. Tenders shall be awarded for a cluster consisting of locations required for commissioning of base station and the trains identified in the cluster for service through 2 packet tender systems. As well as packet A, commissioning of base station is all identified so and so. Then packet B. Now, please see now 3.5.1 at page 51. The losses have page 51. Annual turnover from food and beverage business. Food and beverage business means so and so, and similar rupees 25 crores for cluster A, and please see average per year in any of the 3 years. So during the last 6 years, which means in the last 6 years, if we start from 2018, 24, then in the last 6 years, 3 years at least there should be an average of 25 crores. It means 75 crores must be your annual turnover, and 10 crores average per year in any of the 3 years during the last 6 preceding years. Please turn over the page, page 52. Preceding 6 financial years are 17-18, 18-19, 19-20, 20-21, 21-22. So it gives the retrospective effect that you have now to have this turnover from the past. If the applicant is submitting certified turnover for 18-19, 20-21, 22-23, the total turnover must not be less than 75 crores for cluster A and 30 crores for cluster B. So that's the turnover they are asking. Besides above, there should be no nil turnover during the 18-19, 20-21, 22-23. The losses will see the annual net worth, that the losses may skip, I'm not on that. Then 3.5.3, ownership of kitchen. This again, in my respectful submission is onerous. This for cluster A, ownership of at least 2 operational certified kitchens in any 2 different cities in India with valid FSSAI license, having the capacity to produce at least, please mark 2,500 meals per day each, and proof of supply of at least 45,000 meals each, average 500 meals per day. Meals include lunch, dinner, breakfast in any of the 4 preceding quarters. So it goes back, it reverts back. In the last preceding quarters, this is the capacity which you have to have, namely supplying 2,500 meals per day and proof of supply of 45,000 meals each, average of 500 meals per day in any of the 4 preceding quarters. And for cluster B, same requirement, except that 1 kitchen is required, ownership of 1 kitchen to produce at least 2,500 meals per day and proof of supply of at least 45,000, the same requirement. And if a lot is turn over the page, page 53, joint ventures, JV, consortium shall not be allowed. So what it does is, you are introducing such stringent requirements you are prohibiting joint ventures and consortium. So obviously, my lord, now the list which is there at page 73, 74, you have to test it, fellows. Who are these? Is it ultimately reducing competition? Because CVC guidelines also says, fellows, in such public tenders, you must ensure A, a level playing field, and B, that you should promote competition rather than scuttling the competition.
Hmm.
Now, my lord, also see, my lord, page 101, there is no requirement, my lord, unlike in the earlier tenders, my lord, earlier policy, that there was a maximum cap which one particular bidder could have done, my lord. That, my lord, your lordship will see, my lord. At page 121.
So
Sorry.
here the petitioner,
Yeah.
number 1 and 2,
And
they
number
do not meet the
They will
criteria.
not meet the criteria. In fact, my lord, the submission which I am making across the bar, I have also stated my petition that 73, 74 out of 62 M-panel caterers, only 6 qualified, 4 belong to one particular group. So, my lord, our respectful submission is, my lord, it will, my lord, promote monopoly. B, it will
Then
result
why
in-
you are not making them a party? Any order being passed, if
Yes.
you are saying that it has
No,
been
my lord,
made at the
ultimately,
behest.
my challenge is to my challenge is for them to make good. My challenge is to the policy. I'm saying, my lord, it suffers from egregious arbitrariness on the face of it. But what is the rationale behind such condition? And that too, you are taking it back. It is not that you are saying henceforth. Because, my lord, they have an identified pool. It is
No,
not.
no, you are saying that it cannot be taken back and it has to be on a forwarding thing,
Yes.
or moving forward.
Yes.
Then in that case, the question would be out here is that they cannot implement for the next 6 years.
No, not that. Then they have to do it in such a way that they have to ensure that maximum participants come. How, my lord, one can be consortium? So I don't have the network. I'll take my learned friend with me, my lord, who has the financial turnover. And I will fit, my lord. That's what happens, my lord. You promote competition. Let there be consortium. Let there be JVs. You have prohibited JVs. Expressly, my lord, I pointed out that clause. So now what happens is, out of this list, it is not something they don't know, my lord. They are not coming, the bidders are not coming from elsewhere. This is this list of 762. And this 62, my lord, they know that these are the 62 M-panel caterers who will participate. Who has the wherewithal, who has the capacity, they know, because they have my financial. And what is even more shocking, my lord, is there is no consultation, my lord. You
So
are changing-
wouldn't there be a fresh empanelment after this policy?
They have to come with, because this is going for 1 year. At this moment, my lord, this is the M-panel list which is valid, which is subsisting. It is for 1 year. These are identified by and identified.
Now, how do you say that this is valid for 1 year?
But that's as per the policy, my lord, the empanelment which happens, my lord, it continues for one. It continues for a period of 1 year. So my lordship will see
It's given here.
it is not mentioned here.
No, it is given. Annexure E, it is given 2010-2023 to 31/12/2024.
Yes,
Valid up.
ah,
It is given.
I'm great.
But many others have already, just for example, 29/30.
It's valid up to.
Now they are gone.
Yes, my lord.
They are no longer surviving. You see, these are all up till 31/12/2023. If you see on the right hand side,
Yes, my lord.
valid up to the last, all these from down below,
Yes, my
from
lord.
34 to
There are
22.
few which are surviving till 2024.
No, few are there, but others are already finished.
Yes, ma'am. I mean, either they come
All these are finished. From 62 onwards.
substantial of them. Yes, my lord. Your
Now,
lordship is
from
right.
22 to 62,
Yes, my lord.
they cannot participate. This empanel list is gone.
But my lord, unless they come out and put this continues. That's the practice. That once they because this is my lord, details of M-panel parties for limited tender on board catering services. Otherwise, they'll have nobody, my lord. So they keep updating this list. At this moment, my lord, this is the list which is operating.
Out of 62, only 6 are here.
You notice that, my lord, but
All others are not valid in.
that they have to
And
say.
of these 6, you come out there, 2, 3, 4 are there. 1, 2, 3, 4.
Are there.
Then you have 20 and 21.
I'm
The
grateful.
four services, as of now, the petitioner number
grateful.
1 is not valid.
But it continues unless they come up with a new list, because it can't be, my lord, that they can't have a limited tender, they don't have, my lord, what is
Have
ambitious.
they issued any tender?
Yes, they have now started issuing, my lord, from, I am told the day before yesterday, my lord, after the writ petition was filed.
Hmm.
But my lord, the problem is this, my lord. Today, my lord, you know,
Earlier there was no ban on joint venture.
no, no, my lord, earlier also it was continuing, but it is the.
No, earlier whether joint venture was permitted.
There was no express prohibition on a joint venture.
Joint.
Now, my lord, what has happened is
Hmm.
either they should have allowed, when you're bringing in such stringent requirements of extending that annual turnover, my lord, to such an extent, 75 crores, my lord, in any of the 3 preceding years, in the last 6 years, you should have permitted. Ultimately, my lord, what is the reason? The reason is, my lord, your lordship will see that the expanse of the field should be more, that more bidders come into bid, and so that you get better rate, and there is better competition. That's what even the CBC guidelines say, my lord, that you should not have stringent conditions, my lord, which will oust many of the bidders. Now, my lord, had this empanelment not been there, my lord, I may have had a far more Herculean task. Today, my lord, your list is identified. You know the parties who are eligible.
No,
you
I
know.
think they will have to go for a fresh one because all these except 6, all others are not there.
But this list continues, my lord, unless they come with a fresh one, or because they have to have a list. Because ultimately, my lord, the panel, the pool, they have to know that these are the persons, because it cannot be that somebody somehow comes in, my lord, who has no experience, who has no network, who has no annual turnover. Now you're not even permitting consortium. So, my lord, my respectful submission is this.
Hmm.
None of this, my lord, the listed entities in page 73, 74 were called even for a consultation. My respectful submission is, when you are making such drastic my lord, changes, the stakeholders should be heard, my lord. At least take their consult them. Earlier, my lord, they were doing, my lord, they had called us, my lord, in 121, I have annexed one. My lord,
Mr. Chaudhary, I only find about this joint venture to be a bit difficult to digest. 3.5.7.
yes.
Remaining, I think it's not so.
What is this, my lord? This has to be read. This has to be read, my lord, along.
No, the question is, if you see many judgments of the Supreme Court, right from that particular, but I forgot the name of the judgment. Now, nowadays, joint venture is taken as a legal entity.
Yes, yes.
And why then joint ventures are taken out? That is I think, a very important aspect. Yes. Mr.
It's a
Gogoi.
new horizon judgment.
Yeah,
New
the
horizon.
new horizon.
Regarding the policy laws, page 48, I don't know, kindly come to the objective.
No, I've seen that.
Lordship,
No, everything is accepted.
Lordship,
There's nothing to.
lordship,
But
lordship.
I'm only on the joint venture thing. You see, all other things which now they want to have it, these policies, new things that
For
we are going to have this. That is obviously absolutely
public
within the
interest and
domain
also
of the
better navigation
executive.
that
This
is.
court does not.
Okay.
But the fact that these joint ventures or the consortiums are now legal entities, why you have excluded them?
That part, lordship, probably the decision making process, they have taken the decision.
Because you are now excluding a joint venture who could have otherwise done it. That is the only thing I'm on.
There may be reasons, lordship, the policy.
Why there has to be a reason? Because otherwise it's a legal entity.
Lord.
If if all tenders can be given all over the world, all over India, you are having various tenders, all mostly are joint ventures. Then why joint venture has been included?
There may be some logic, lordship,
There
because lordship, the joint ventures, lordship, some parties are lordship, they are failed to lordship, provide the service, lordship. In other tenders also, railway, general tender.
Joint venture, they will be bound by that.
Lordship. They
They'll
are
be
bound by their, bound by the other
no,
partners,
why I'm
lordship.
saying is, in all contracts, you are making the joint venture.
Lordship, lordship.
Then if that is there and all contracts are happening,
Okay.
what is your problem with a joint venture when that too it's a legal entity? Other aspects are okay. Other aspects will obviously come within the ambit of a policy making, which I'm not. But to take out the joint venture would be taking out the right of participation of certain individuals who could have otherwise done it by joint venture, who may be capable of. Otherwise, obviously, nowadays, for 75 crores is not a big amount
Lord,
for many.
Lord.
These type of the train, 75 crores is
Lordship,
peanuts.
not only it is not for a one page, a cluster of 10.
No, 75 crores is too
Lordship.
small. It's not on that. I'm only on the question of joint venture. We'll do one thing. We issue a short notice.
Lordship.
You get your instructions, file an affidavit on this
Regarding
aspect on the joint venture.
Lordship.
Let's look. What the aspect, just a page 93, my lord.
Hmm.
There was a cap, my lord, on the number of contracts which a particular entity could hold, my lord,
Hmm.
under the earlier policy.
Hmm.
Just a page 93, my lord, 19.3.4.
Hmm.
The last two lines, a licensee will be allowed to hold a maximum of 10% of similar category of
19.3.
page 93, my lord.
All mobile units and AIS shall be managed departmentally. No. Page 93. Which one?
Page
It's
19
a earlier policy, Lordship.
19.3.4, my lord.
19 point mobile unit.
All
and
mobile units and base stations shall be managed departmentally progressively in a phase. Until the departmental is complete, a licensee will be allowed to hold a maximum of 10% of similar category of major units under the Indian Railway. So there was a cap that a particular trader or a particular caterer, my lords, could have hold a maximum of 10%. This cap, my lord, is removed now. It's not here in the recent policy. Now, what is going to happen, my lord, is it will create a monopoly. It will result in cartelization. And I have already stated, my lord, pages 73, 74, except 6 entities, which actually makes it to 2 because 4 are.
No, Mr. Chaudhary, there is a reason why this has been done. Because this 2010 policy when it came in. Thereupon there was a there was a move for moving it to IRTC.
Lordship.
That is the
2017.
reason. Yes.
Yes.
That is the reason why they were thinking that before the departmental thing which takes up, that is the IRCTC,
Yes, my lord.
they are going to have a cap on that.
Lordship.
No, my lord. Even
No,
Even-
it's for a cluster, Lordship, not a
in
Lordship.
2017 policy also, my lord,
Hmm.
IRCTC mainly unbundled. That mainly now the preparation of food and the serving will be from outside, my lord, from a base kitchen. But my lord, there is no such cap. My respectful submission is, my lord, it will promote, my lord, monopoly. There is no cap, my lord, there is no control. And the conditions, my lord, have been made so stringent.
You have submitted a representation?
Yes, my lord, that your lordship will find, my lord, at page 131.
5/1/2024.
Yes, my lord.
This policy was done, Lordship, on the basis of the past experience of the railways, Lordship. It's a public interest, it's an interest to the passengers, Lordship.
That is okay. But
Lordship.
why haven't you taken that point of joint venture on your
Joint venture part, Lordship, I will clarify, Lordship. The
No,
reason behind-
Mr. Chaudhary, why haven't you taken the point of joint venture in your
They
representation?
are not a joint venture, Lordship. So that's why they are not taking the part, Lordship.
So these are
That point has not been taken.
The joint venture is not before the honorable court, Lordship. They are not agreed by this policy, Lordship. They are not a single party has come before the honorable court, Lordship.
That is one problem. That I put- But then also
They are
this
not
policy-
affected parties, so they are
Because
not
this
enforcing the court, Lordship.
representation, you have not taken that aspect of the matter.
because the depth of later of balance. Bring the writ came, my lord, for settling.
Yes, because they are not a joint venture. company.
Mr. Chaudhary, I think better off we'll issue notice to him. Let him file his reply. And I'll fix the date on a particular date on which.
And let them also answer, my lord, now at per page 73, 74. Who are the caterers who meet this policy? Let them answer this much. Everything will be clear.
Okay.
I have stated in my writ.
Issue notice.
Meanwhile, my lord, I request for some protection. My lord. Otherwise, what is going to happen is they are proceeding, my lord, if a notice will see with the just have my lord page 122.
Mr. Chaudhary, I am only satisfied on as regards the joint venture.
That's
And
it.
joint
That
venture
is a
point
good
you have
point.
not
Now,
raised.
I will satisfy your
Not
lordship
before
for
the
other issues
honorable
also.
court, Lordship. Joint venture is not before the
No,
honorable court. They are not
let me
agreed,
issue
Lordship.
notice out here.
They are
We'll-
not
we'll
agreed,
see
Lordship.
to it.
It's a
In
public
some
policy,
section,
Lordship, in the
otherwise what will
interest
happen,
of
my
the
lord?
Lordship.
No, nothing is
This
have
is-
not,
this is my lord.
no, there won't.
Create a Pandora's
I grant you, I will grant you a liberty for filing this case if there is any problem.
No, my lord. But the difficulty
Issue
is this, my lord.
notice making it.
It's a
Oh, yes,
public
when can
policy
you
in the
file your
interest of
affidavit?
public and passengers, Lordship.
When can you file your affidavit?
Lordship, within a period of 2 weeks or 4 weeks, Lordship.
3 weeks.
3 weeks. Lordship.
Issue notice today is issue notice making it returnable on 20 22/2020.
Lordship, first week of March.
Why? I've given you 3 weeks. You are asking for 3 weeks. I've given you 3 weeks. Issue notice making it returnable on 20/2/2024. The Mr. Gogoi
Time for all right.
appears on behalf of all the respondents and accepts notes, extra copies of the petition disturbed upon him during the course of the day. The petitioners herein have assailed the circular dated 14/11/2023 issued by the Ministry of Railway Board, Government of India, on the ground that the said circular has been tailor-made in order to grant certain benefits to a handful of empaneled contractors, and thereby depriving various other empaneled contractors. The learned counsel appearing on behalf of the petition, learned senior counsel appearing on behalf of the petition, submits that the eligibility criteria which has been put at 3.5 is arbitrary and unreasonable, and without taking into account that this would result in reducing the participation, which would not be in consonance with the CVC guidelines. The learned counsel, senior counsel, further submitted that as per clause 3.5.7, joint venture bracket JV oblique the consortium have been made not eligible, and there is no reason to do so in view of the fact that a joint venture bracket JV oblique consortium is a legal entity as well settled by various judgments of the Supreme Court. He therefore admitted that these aspects would clearly show that the respondent authorities have, in order to confer benefit on a handful of empaneled contractors, have issued the impugned circular. Mr. K. Gogoi, the learned counsel appearing on behalf of the respondent, submits that he would like to take instructions on the aspect of the matter and put the same by way of an affidavit. Taking into account the above, this court directs the respondent authority to file the affidavit by 12th of February 2024. The petitioner thereupon would be at liberty to file any reply on or before 19th of February 2024. The learned counsel, senior counsel appearing on behalf of the petitioner, submits that there has to be some interim, that certain interim protection is required to be given, in as much as the petitioners herein, who are otherwise empaneled as per Annexure E, would be deprived of participation in the newly issued tenders as per the new circular dated impugned circular dated 14/11/2023. This court, for the present, is not inclined to pass any interim order. However, the interim order shall be considered on the returnable date if the writ petition cannot be taken up for final disposal.
Their last date of submission of bids is 15/2/2024. It is there should be some Nothing is happening, my lord. Trains are
The last date of submission of what?
15 February 2024.
What is that?
This is the new tender which was
You have not enclosed this.
it came after the filing or after the service of this petition on my learned friend. My lord. This is what is happening. That's what they do. Well, what is happening is now 15th February, my lord, will just see this. By 20th, my lord, this date will go. All I am saying is, my lord, that the catering contract are otherwise been executed. They are giving them attention to the persons who are currently doing it. My lord, earlier it was 6 months, now they are giving 15 days. Let them at least continue this, at least maintain status quo till the next day.
Which contract?
No,
Which
my lord,
contract?
my lord, what I'm saying is, insofar as the policy is concerned, let them maintain status quo, my lord, insofar as the policy is concerned. Otherwise, we are ousted, my lord, from this date. Completely ousted.
Why?
Because 15th is the last date for submission. After which, my lord, they will proceed.
So are you have to file an IA to the effect that you are going to go have a joint JV with somebody.
Maybe all that I'll say, my lord. Today, my lord, when a lot is
As of now, without
your
that
lordship is-
tender,
lordship
this
is considering the matter, my lord. All I'm
no,
saying, my
Mr.
lord,
Chaudhary, sorry.
subject to meeting your lordship's approval, my lord.
No.
Let my lord-
I can give you a liberty for filing an IA. That's all. You have file an IA saying that we are considering of having a JV out here, and I'm not in a position to submit that and in pursuance to this tender which has come after filing, and bring it. Then we'll pass appropriate orders.
or otherwise, may I hand over, but otherwise, everything is before your
This
lordship.
is without the pleading.
I have
Mr.
stated so, my lord.
Chaudhary, I told you,
Can you
I am
send
not,
us
I am not
It will be very
satisfied.
difficult, my lord,
I
later on
am
to
not
ask-
satisfied.
unscramble the scramble date, my lord. On the scramble, my lord, it will be very difficult. That's why I'm
No,
subject
there's
to
no
meeting your
problem. I
lordship.
give you the liberty. I give you the liberty. Mr. Chaudhary, the Learned Senior Counsel appearing on behalf of the petitioner submitted that there is some fresh tender which had been issued pursuant to the filing of the writ petition, and submitted that some interim order is required to be passed for maintaining the status. It is the opinion of this court that without the said aspect being brought on record by way of appropriate pleadings and by filing appropriate application, any order so passed would not be in the interest of justice. Under such circumstances, liberty is given to the petitioner to file appropriate application, seeking interim orders if deemed. You file an application.
And my lord, obviously needless to state, my lord, that any action which taken will be subject to the outcome of this case. Any action they proceed, my lord. Because I have challenged the whole genesis of the policy. That also may be clarified.
That I can pass. Without you don't want anything.
No, I will
of
file
this.
the IA, my lord, but my lord, otherwise, my lord, this observation, my lord, should come, my lord, let them also understand, my lord, that this is what they have done.
Otherwise, where is the violation of the
It's
rules
needless-
and regulation, Lordship? Where is the violation of constitutional provisions, Lordship? Where is the violation of statutory rules, Lordship, in
My
the
friend
policy,
is willing to
Lordship?
argue today, my
In
lord,
the policy, Lordship?
No,
It's a
it's
public
okay.
interest,
We
Lordship.
will see.
It's a public interest, Lordship.
These order will be there. Don't worry.
Then the further what is the so they were also the and the rejection while giving the not
Now, they are referring to some rule 48 Roman 3.
there that is not there your worship.
Huh?
There is no such rule here.
That is what? What is this? Who is appearing? What is this rule 48 3? Where? Then what did he mention about?
The book lordship up to Roman 2 is available. Lordship.
I think he must have referred to this one, na? The lease value will be fixed for a period of 7 years at a time with 10% annual increase.
Right.
I think he must have mentioned this.
Okay.
Submitting the bid as per demand of the and the bidders quoted differential and arbitrary annual rate for different years. Yes, what was the rate quoted by you? Let's see.
1 lakh.
Huh?
Not in the bidding. It is not the bidding. It's 1 lakh. Not in the bidding.
1 lakh
50,000.
and every year increase. Have you mentioned?
No, not.
Then what is wrong with that order?
But it's an RTI application has been made for it, but it has not been given to us.
No, but you have to show that you are not in violation of this Route 48. Your bid was not in violation. What is the order say? That whereas instead of submitting bid as per 48.3 of the issuance, the bidders quoted differential and arbitrary annual rates for different years. This led to irregular and inconsistent bids, resulting in abnormally low rates for initial year and abnormally higher rates for later years. Whereas the tender committee found that the highest rate was of Provea on the basis of all the 7 years combined, and he proposed differential and arbitrary revenue for each year in his bid. Whereas as per the decision, the highest bid was bidder was asked to submit a written proposal within 3 years to submit a bid for the first year and yearly increment of 10%, which is as per this, per year as per Rule 48.3 of the student. However, no proposal was received with the stipulated that as the higher had differential bid in a year, but he has not submitted rate of 12. Now, did you submit your bid
Yes.
in this manner? The first year this much, second year 10% increase, third year this much.
But if the petitioner has submitted everything in the fair.
What is this fair manner business? I'm not saying, I'm asking you a simple question
Yes, sir.
as to did you submit your bid in this manner?
Yes, sir.
Where is it?
It was submitted, Your Lordship.
Show
Yes,
me.
but the petitioner doesn't have in their hand, Your Lordship. RTI application has
No,
been
you
made
must
to
have
it.
stated out there that because that is the only ground you are to settle. You are asking for setting aside this order.
Yes.
It is that your bid was not in an arbitrary manner. Did you quote the bid in this manner that the lease value will be fixed for a period of 7 years at a time with 10% annual increase? Did you submit? What was the bid submitted by you? Let us see. Where is your statement that you did not submit any arbitrary bid? No statement.
Statement.
Huh?
Statement was not.
How do I consider your case?
But the RTI application has been made for it.
RTI application is okay, but what bid you submitted, you must have said. You should have said. You have not stated anything. Your only case is, look here, the deputy commissioner only took into account the number one
Yes.
and
We're telling
have
you that
cancelled
also,
it
no.
without giving us an opportunity.
Because
But the
you-
fact that you have submitted, you did not submit an arbitrary bid, isn't it required to be stated?
we are telling you the order of the 30/12/2023 euros based on the fact that they have not mentioned specifically about us. What is the
It has been mentioned that all bidders,
Yes.
all bidders have done it. Isn't it required on affidavit to state that your bid was not arbitrary? Have you mentioned a single word on this? Yeah. How can I help you? Tell me. Now become number one instead of number three. Because here the bid, the fixation of the bid or the minimum amount, the jurisdiction is absolutely with the deputy.
Okay.
Without a single statement on your part that my bid was never how to help you?
Even then, the opportunity was given, number one bidder.
Understood, but he said that all bidders have given this. And as such, we asked number one who cumulatively for 7 years was the highest to give a proper. He did not. So we are going for a fresh tender.
If there was nobody in our part
So
of
the
the same,
government wants the best option out there. So let them do it.
if the same thing happened with the bidder number one, if he was given the same opportunity to correct it, then it's also given to us if there is any difficulty on our part. Because everything was the same. The three bidders, successful bidders, one was, there was anomaly on the part of us, it is been clearly mentioned. Even that he was given at fixed period of time.
What about the bidder number two?
Bidder number two has, I don't know whether he has challenged it.
Now, if you let us assume that you are successful, then what? Are you going to get it?
Okay, then if two doesn't come into the play, then we will definitely get it. Okay. Again, it's not that the two will definitely get it. There must be some anomaly on their part. They cannot submit something. They have not challenged it. Also.
And when is the next date for submission?
Today is the last date of submission of the next press at the 2 p.m. of 1/83.
You submit. You submit. But however, your submission, everything will be kept taken down.
It may be recorded. But that thing may be recorded too.
What?
That can be included with the data stages.
Yes, I'm recording it. I'm just telling you before. To notice making it returnable. On when, Fishery, Deputy Commissioner, when can you get it? It needs to be done early.
Lord.
To notice making it returnable on 2nd of February.
Lord.
2nd of February, 2024. Mr.
Yes, sir.
S.R. Burua appears on behalf of the respondent number 1, 2,
One,
1, 3,
no, Lordship, only 3, 4,
1, 1, 1.
one fishery
Okay.
department
Appears on behalf of the respondent number 3 and 4.
and 6, Lord.
3, 4, and 6. Mr. P. Sharma appears on behalf of the respondent number 1, 2, 1 and 2.
Yes, sir.
The N.K. Devnath appears on behalf of the respondent number 5, 6, and 7.
Yes.
Taking into account that all
Seven.
the
7 o'clock.
all the respondents are duly represented, extra copies of the petition be furnished to them during the course of the day. 7 is who?
Zonal development.
You.
Finance, then the PNR,
Anyways, finalized amongst you.
I am for
And then
3,
in-
3, 4, and 6.
We don't.
The petitioner herein have assailed the order dated 30/12/2023 passed by the District Commissioner, Nagaon, whereby the tender which was issued on 1/9/2023 was cancelled and a decision was taken to issue a fresh tender. It is the case of the petitioner that the District Commissioner, Nagaon, had arbitrarily cancelled the entire earlier tender process without giving an opportunity to the petitioner, who was the third highest bidder. The learned counsel appearing on behalf of the petitioner submitted that on the very day another tender notice was issued on 30/12/2023, and there was a direction that the bids would be accepted on 22/1/2000 up to 22/1/2024 till 2 p.m. But it will be closed today, na?
Yes.
Then what happens? It will be extended by tomorrow.
They will not.
It has to be extended. Because when the bid is given as 22/1/2024 till 2 p.m. and till 2 p.m. the office is closed.
Yes, it will start from 2:30.
So then
And tomorrow is also holiday. Lord.
Then
After 2:30, Lord, because it will be open.
and as such had submitted that the said tender process initiated by the tender dated 30/12/2023 be stayed pending disposal of the instant petition. This court have also heard Mr. S.R. Borua, the learned counsel appearing on behalf of the District Commission of Nagaon, and who had also submitted that there is a half-day government holiday declared today up till 2 p.m.
2:30.
2:30. And as such, it would not be possible to accept the said tender up till 2 p.m., 2:30 today. He, however, submitted that after 2:30, the said offices would be reopened. Taking into account the above, this court is not inclined on the basis of the materials on report to stay the said tender process dated 30/12/2023, initiated on the basis of the NIT dated 30/12/2023. The petitioner be permitted the petitioner, if so advised, to be at liberty to submit the tender, submit his bid in pursuance to the notice inviting tender dated 30/12/2023 till 4:30 p.m. The office is open till
They may extend it also, Lord.
Huh?
Sorry, I'm sorry. They may extend it also.
that I know, but the office is open till what?
5.
Till 5 p.m. of today. If the district commissioner, Nagaon, does not further extend the said does not extend the period any further. It is, however, made clear that the submission of the tender bid by the petition pursuant to the notice inviting tender dated 30/12/2023 shall be subject to the outcome of the writ petition. Mr. S.R. Borua, the learned counsel appearing on behalf of the District Commissioner Nagaon, is directed to telephonically intimate the District Commissioner Nagaon about the order of hearing today. You permit him till 5 o'clock.
Lord.
If you are not extending it beyond that period.
Lord.
Oblige.
Oblige.
Highly obliged.
Yes.
Yes, I have, Madam, we have really, my lord, I am quite proceeding.
They were initiated, my lord. And subsequent to my lord, seizure of some document by the Putin Civil Supply Corp. Now, a seizure was taken on 27/9/2023, my lord. They, my lord, this, my lord, found the original document without complying with the provisions of the law. So that's the subject matter of challenge before this honorable court in a different read petition which is pending, my
Which one?
lord. It is WPC number, lordship,
Relating to what?
relating to, my lord, the seizure of 13 documents, my lord, during the inspection, my lord. So our context and restriction is that are not done in pursuance of the provisions of the law later because no independent is nothing was there, my
But your case out here is that you have been kept under suspension.
suspension, my lord. Now, subsequent to suspension, my lord, they, my lord, filed an inquiry report. And we filed a reply to suspension notice, my lord.
But they have
Sir,
not taken anything.
No, my lord, because of that, they again given a fresh inquiry to a different magistrate, my lord. We also call for a personal evidence. We sought for a report of this. Because what is I understand from this case is that the entire thing was initiated on the basis of a private complaint, my lord, by some of the consumers. Their complaint petition was not given to us. Their consumer is not even examined by the my lord, the authority concerned. We asked for the report. Despite of that, we submitted our statement, my lord. Now we obtained what we obtained as, my lord. They now cancel our, my lord, the license without doing all this. Without giving, we should have been given a fair opportunity. We have given an opportunity to go through the report, at least make a submission against the report. We should be given, they should have examined the complaint, or at least a copy of the complaint should be given to us. What is the complaint against us? We do not know nothing, my lord. So
No, you are still under suspension.
we are still, the suspension period is also over, man. It is 90 days. It was given on 9/10/2023. Now we are on, my lord, 22. As per rule 15 one also, my lord, that period expired. Lordship judgment is also there, my lord.
We'll have it on 29, same type matter. Get your instructions, what you have done as regards the inquiry against him, and how can you keep on PTS under suspension for more than days without a show cause?
So in this case, Lord, the show cause notice was served.
No, not for a show cause notice is for cancellation.
Yes.
You have initiated that. That is okay. What you have done is not known to him till now. As regards the other aspect pertaining to suspension, a PDS license can be suspended for a period of 90 days without a show. But after 90 days, you have to issue a show cause for the purpose of further continuing with the so that is why we are going to have issue notice making it returnable on 29/1/2024. Mr. S.R. Burua appears on behalf of the respondent number 1, 2,
All the
all the respondents?
Lord.
All the respondents. And accepts notice to some extra copies of the writ petition be served upon him during the course of the day. The petitioner herein is aggrieved by the continuation of the suspension of his fair price shop license since when?
9/10/2020.
9/10/2023. Oh, it is over 90 days. Since 9/10/2023. Inasmuch as the 90 days is over, which is contrary to clause 15(2) of the Assam Public Distribution. What is that name?
My lord.
Assam Public Distribution.
Assam Public Distribution, my lord. Assam Public Distribution of Article Order 1980.
Articles Order of 1982. The respondent shall apprise this court on the returnable date as to why the petitioner's license is kept suspended beyond the period of 90 days, and as to whether there has been any issuance of a show cause notice for extending the state suspension order.
My lord, then they may not be, otherwise they may cancel, my lord, in the meantime. If they not cancel, my lord, pass into the inquiry. They may not cancel, my lord, proceed further in the inquiry.
How can I say so about the inquiry?
No,
Let us look into
what I
that.
just submit, my lord. We have appeared, if they cancel the license in the meantime, my lord, then my lord, that will,
We'll see if they cancel. It's on next Monday.
not sure, not sure.
We'll see if they cancel it very well. You file another petition. Yes.
May I plead the Lord? My lord, petitioner's land measuring about 69 acres was acquired in the year 1991, 2011, my. Out of this 69 acres, 1 kata 10 lessons of land, 21 acres, 4 kata 14 kata state Pari land, and 47 acres, 1 kata.
Yes,
Yes,
I asked you to
yes,
get me
Lordship.
that detail on the last occasion. What is the
Lordship,
beneficiary?
Lordship asked me to submit the beneficiary list. I think my first other instructions are also there. My lord. First, I'm placing the beneficiary.
They filed their affidavit. my
Uh,
lord.
First of all, Mr. Counsel, who is not well? You are not well. Why did you mention the matter for upgrading?
My lord,
Huh?
on separate location, it was.
No, you mentioned that you are not well.
No, my lord. My lord, I mentioned, my lord, several location it was fixed, and we could not do the matter. I am on pressure, my lord.
The matter was listed on 8/1/2024 and I fixed it today.
My lord.
I fixed it today. So why you are saying that the matter has not been listed earlier?
On several location it was listed, my lord. But we
Mr.
could not
Counsel,
do, my
are you aware of the last order passed on 8/1/2024?
on that day we make a mention, we make an action on that earlier two occasions.
I am saying about 8/1/2024. On that date, I don't know who, Mr. A.S. Ali had appeared.
My lord,
And on that day, I have taken up the matter and fixed the matter today. Then why did you mention this matter for upgrading?
my lord, again, my lord, on earlier occasion, on 9.
Forget about the earlier occasion. On 8/1/2024,
Yes,
this
yes.
order was there, and today this court had fixed this matter.
My lord,
Then what was wrong? What was the problem?
that matter no problem, my lord.
Then why did you ask for upgrading? That saying that you are not well?
That's my lord, I told to the lordship, my lord. On earlier two occasions, my lord, we took time, my lord. We took atonement, my lord, for our personal difficulty. My lord, that's why, my lord, I.
Yes, Mr. Goswami, these matters, whether the petitioner's name appears out here?
yes, their name appears.
And they have received the
There
amount?
is yes. They have there is no
Only
outstanding.
64,000 amount was left. You
Yes,
could not
that is
disperse
not,
on account
not in respect of the petitioner.
for somebody else. Then what remains?
No, my lord, initially your loss of kindly city page 68.
That probable my lord estimate that they have referred to me.
Huh?
The probable estimate they have referred to now.
No. If
It
you are
is not
agreeing,
probable estimate. My lord, kindly see page 68, 69 and 70, my lord.
page,
68,
yes,
69 and 70.
yes. What is this?
I beg to draw your lordship attention to page 69.
Ah.
The arrearable Pari land is 21 bigger 4 kata, 14 chatak. It was fixed at a rate of 1,25,000 per bigger.
Mm.
Then Bajar Thali land,
Mm.
47 bigger 1 kata 16 chatak. It was fixed at a rate of 1 lakh per kata. So total calculation came 74 lakh 78,500 in respect of land matter. Then their house fees and other fees, it was calculated total value at 3 lakh 30,
No, no, Mr. Raghuvan, kindly
lord.
tell me only one thing. The amount which was sanctioned
Yes.
and the award was passed
Yes.
is in respect to an amount of rupees 2 crores 71 lakhs and odd.
No, my lord, kindly say page 70, my page 70, total calculation.
Yes.
Total calculation around rupees 4 crores.
No, 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 no. This is an estimate. What is the award passed? Award is of 2 crores 71.
Yes.
You are agree with this? This is a acquisition done under what provision? Acquisition done under what provision? Assam right to fair compensation? Assam right to land acquisition and requisition act? 64. So then you file an application under section 12 for enhancement. So all these documents there. How can this court look into it? What is the value of the land?
My lord, I just, in this aspect, I beg to draw your lordship attention to page 70 bottom line.
I've looked into it. It is 4 crores something.
Yes, page 50
This is
bottom
an
line.
estimate.
Classified there.
Understood. This is an estimate. But in spite of this estimate, they have come up and paid and come up with an award of rupees 2 crores 71 lakh. And after that, what are you going to do? You are not satisfied with it. Move an application under section 12. That is the only recourse. Because once an award is passed, it has attained finality. This court cannot direct the authorities concerned to reopen it. The reopening can be done as per the act. Otherwise, wouldn't this court be exercising a writ contrary to the provisions of the law? Because on the last occasion, this matter was fixed only for the purpose because the counsel appearing on behalf of the petitioner did not inform us as to whether the amount of rupees 2 crores 64 lakhs and odd have been paid to them or not. That is the only reason why I have to fix
That
it.
has been paid back.
So if that is being paid out there, then in that regard, if you are aggrieved by the amount, then you are to move an application under section 12. That is the only way out. There's no other way out. And there are many judgments I have delivered in this regard. Isn't it, Mr. Barbuzari? That case of PK Sarag, that Saragi traders or something, I forgot the name is. Because you see, the Supreme Court in the judgment in Sardar Das categorically observed that once an award has been passed, it has attained finality and it can be only modified or challenged, removed. The finality or the conclusiveness arrived at in that award can only be touched by the civil court. And if that be so, you are to go under section 12, they will make a reference and then fight it out. You ask for 1 lakh, 2 lakh, whatever may be. That's all. Not only that, it's a question of how can this court look into it? It is 1 lakh or 2 lakhs or whatever may be. It will all be dependent on various documents to be placed. You are to prove it that yes, this is the amount. That is why the interest which is being given is 9% and 15%. Do you get this type of interest in the bank? No.
All right, matter. Then your lordship may close the matter with the direction for further.
The instant writ petition has been filed by the petitioner. Being aggrieved by non-payment, being aggrieved by the amount, by the inadequacy of the compensation awarded to the petitioner in relation to LA case number 1/2011-12 arising out of the acquired land of the bona fide owners of the Patadas measuring 69 bighas 1 katha 10 lecha under the special scheme for construction dike, namely inverted comma LA immediate measuring to close the breach at chain is CH dot 13th kilometer bracket at Solmare bracket close of B oblique dike from Harmuza to Balikusi due to diversion of channel of river Brahmaputra, including A oblique E, measure for 2010-11 under CRF, inverted comma close. It is the case of the petitioner that originally, while preparing the estimate, the Deputy Commissioner had duly certified that the total amount was rupees 4 crores 54 lakhs 60,360.62. Comma 361 boli koi, 361. However, at the time of passing the award, the awarded amount was rupees 2 crores 71 lakhs 37,631. Under such circumstances, the petitioners being aggrieved had approached this court, seeking a direction upon the respondent authorities to redetermine the compensation and pay the balance amount of rupees 1 crore 83 lakhs 22,730. This court have also perused the materials on record, including the documents which were placed by Mr. B. Goswami, the learned Additional Advocate General, Assam, who submitted that the awarded amount was rupees 2 crores 71 lakhs 37,631, and out of which an amount of rupees 2 crores 46 lakhs 54,200 was duly paid, and the remaining amount of rupees 24 lakhs 83,431 was on account of government contingency oblique establishment cost, etc. He further submitted that out of this amount of rupees 2 crores 46 lakhs 54,200, an amount of rupees 2 crores 45 lakhs 90,139 have already been released, and the remaining amount of rupees 64,061, however, as could not be released in view of the fact that certain beneficiaries have not submitted all the documents. The learned counsel, the Additional Advocate General further submitted that if the petitioner herein is aggrieved by the inadequacy of compensation, the petitioner has to approach in terms with Section 12 of the Assam Land Bracket Requisition and Acquisition Act 1964 before the collector, and thereupon the collector would make a reference to the court wherein the aspect as to whether the petitioners are entitled to any higher amount or not would be adjudged. This court have also taken note of the fact that they've taken note of the well-settled principle by the Supreme Court in the case of Sardar Das versus, you have the citation? Sardar Das versus, it is there in my judgment, that judgment in Saraugi. আপোনাক সেইদিনা দিছিল যে বৰঠাকুৰক দি দিছিল তো আছেনে আপোনাৰ তাত? হা হা This court at this stage finds it very pertinent to take note of a judgment delivered by this court in the case of Sawarmal Agarwal and 27 others versus the state of Assam. Versus the Union of India and 9 others. Bracket WPC number 4947/2014, dated 14/11/2023. In the said judgment, this court had duly taken note of the judgment of the Supreme Court in the case of Sardar Devi versus State of Bihar and another, reported in 2003 3 SCC 128, and observed that the award made by the collector is final and conclusive as between the collector and the person interested, whether they have appeared before the collector or not, on the following issues, that is, Roman 1, as to the area, that is the measurement of the land required; Roman 2, as to the value of the land, that is the amount of compensation; and Roman 3, as to the apportionment of the compensation amongst the persons interested. It was further observed that the court, that pursuant to the passing of the award, the collector becomes functus officio and it would only be, and the same can only be, and the finality and the conclusiveness, finality and conclusiveness arrived in respect to the award can be varied by the civil court, varied / superseded by the civil court, in accordance with the provisions of the law, and in that case, the provisions of the Assam Land Acquisition, Requisition and Acquisition Act 1964. Paragraph 16 to 21 of the said judgment in the case of Sagarmal Agarwala and Sagarmal Agarwala Supra is quoted here in below. Taking into account, in the backdrop of the above settled principles of law, and applying the same to the facts of the instant case. It is the opinion of this court that the petitioner herein, if so aggrieved with the inadequacy of the compensation, has to approach the collector in terms with Section 12 of the Assam Land Acquisition and Requisition and Acquisition Act 1894 and 1964. Ito akote likhi দিব short act. And thereupon, upon approaching the collector, that is the district commissioner, which one? Gwalpara, has to refer the matter has to make a reference to the court of the district judge, Gwalpara.
Yes.
Accordingly, this court therefore disposes of the instant petition with the following observations and directions. Number one, this court is not inclined to issue a writ to the district commissioner of the collector Gwalpara to redetermine the compensation on the basis of inadequacy. However, this court grants liberty to the petitioners to file respective applications before the collector of the district commissioner Gwalpara forthwith and not later than 45 days from today. Number three. Number two, the district commissioner of the collector Gwalpara, upon receipt of the respective application, bracket S, so filed by the petitioners within the time permitted by this court, shall within 30 days therefrom make the reference to the court of the district judge Gwalpara. Number three, this court further directs that the reference court, that is, in the eventuality, it is found that the petitioners would be entitled to the compensation, to a higher compensation, this court further directs this court further takes note of that almost 3 years have passed by. When was the award passed?
Five, 12, 29/11/2011.
Huh?
Sorry.
No.
5/12/2011.
Award was passed.
Yes. That is this.
We have not got a copy of it. It is the final, that is in their affidavit dated 31st December 2011. The estimate for my land.
No, that is the order passed by the office of the deputy commissioner and the concerned, my lord, revenue official, my lord.
Their affidavit page 10, madam.
Uh,
35.
the final estimate is dated, so we'll have it 31/12.
Uh,
This court have also taken note of
Gazette notification is
when dated
that is 31st December 2008.
This court have also taken note of that the award was passed on 31/12/2011. If there is an increase, if there is any enhancement, however, the petitioners have not approached the collector till date in terms with Section 12 of the Act of 1964. Under such circumstances, it is the opinion of the court that in the circumstance there is any enhancement on the compensation amount, there would be no payment of interest for the period from the date of passing of the award till the date of filing of the application by the petitioner. However, upon filing of the application before the collector, and in terms with the liberty herein above granted, and there is any enhancement, the petitioner would be entitled to enhancement interest on the enhanced amount with effect from the date of the application. Next. This court further directs the District Commissioner Gwalpara / the Collector Gwalpara to forthwith transmit make the reference, in as much as any delay in making the reference would lead to incurring of higher interest, incurring of additional interest on account of the delay in making the reference. With the above, the instant petition stands exposed. These matters should have been finished on that date. I did. Yes, yes. I will again look into it as to whether it were not well or something. Anyway. Yes, madam, what is this? Oh. Even
On Friday itself, it has been deposited to the Deputy Commissioner, Kamru Kattur.
so you will get that money. Now the question is of requisition. You can't keep the letter for requisition. What are the steps? Because on the last occasion, the question was, whenever the matter earlier had come up, that you can't keep the land for like, and there were certain steps being taken. What has happened?
But that was the District Commissioner who was supposed to place the request.
Yes. Revenue, what do you have to say?
The annexure F40 page 20, there was proposal for an acquisition annexure C page 16.
And that I know. I remember this matter. That is the matter pertaining to the GMC, na? Yes, what steps are you taking? You can't keep the land for requisition.
Yes,
It goes against the very spirit.
Yes.
Then what are you doing? In fact, on the last occasion, there were certain movements as for acquisition when the matter was taken up. Yes, on 18/10/2023, when the matter came up, had filed an affidavit stating inter alia that the land measuring 8 bighas covered by so-and-so would be acquisitioned as per the provisions of Iman. it was mentioned that though the land would be acquired as per the app, but the compensation would be determined in accordance with section 29, 26 to 30 of IMA. Be that as it means, there is no mention as to what proposal has been initiated in that regard. This court, in the meantime, the Deputy Commissioner here shall apprise this court about the progress as regards the acquisition proposal.
So
What is that?
Yes, that order was passed, my lord. It always take on the strength of the instruction, my lord, received, my lord, from the office of the Additional Deputy Commissioner. That instruction is dated 13/10/2023. I hope it is here.
My order is on 18.
Yes, it is there. Now that instruction says, my lord, that the circle officer DPU has submitted a fresh acquisition proposal by this letter dated 12/10/23. Preparation of estimate as per fresh proposal and follow-up action will be taken as per rule. Now what has happened there?
But Mr. Porputari, see, this is after all public money.
Absolutely.
The more you delay,
Yes,
the more
yes,
price you are
yes,
going to.
yes, yes, absolutely.
And one fine day, this requisition have not gone into until now. But this requisition will have to be held to be bad. Because you can't keep a land requisition from 1983, na? Or 62 for such a long time. Not possible. Requisition is only for temporary people. And you, whatever you are paying is very peanuts. Pay as per the actual land value, we pay. You are not even, that amount which you are paying doesn't even commensurate with the land revenue. The land revenue now would have gone many. I think you are getting around 35,000 or something for 5 years.
Deduct paid and now deduct up to 2000, year 2000. So rest of the year they have not calculated and not yet paid.
So what are you doing? Do something. Instead of spending on money elsewhere, do something. This is a health structure.
Yes.
Because tomorrow it will have a huge problem you are going to. And once this court holds it, this acquisition is bad, then requisition is, you can't continue like this. Then the only thing is, and any delay. And I don't understand what is the problem with the circle officer in making the acquisition proceedings fast or do whatever it is. If it is done, then only things will happen.
No, circle
And every year the price value of the land is going up.
Now, my lord, the circle officer has already submitted a fresh acquisition proposal. It is he has already done his part. Lordship will call for a status report, my lord, from the District Commissioner Kamrup Metro. That will, my lord, clarify everything. Lordship will issue strict charges. Lordship, if my lord is not satisfied with the report, status report, with regard to acquisition, what is happening with regard to formal acquisition? There has to be a formal proceeding. Now, if nothing has, my lord, progressed,
no, they have to understand, because any delay, the only price is going up.
Absolutely. Now 2015 rules will come into play.
15 to everything will come in. The problem is the price every year the price is going up.
Yes.
And it is on it. This land would have been in 1980s. This land could have been very well got around in 10 lakhs or 12 lakhs. You could have been very easily able.
Absolutely.
Now you won't even get it in 10 crores. 10 crores is, can you even go there? Because the land out there has become too expensive.
Even, my lord, on our part also, my lord, we have been persuading the authorities, my lord, that do it quickly. Letters are here, my lord.
I understood, but something has to be done. If you don't do it, you see, we are concerned with the public revenue. Public exchequer is involved.
Lordship will kindly observe, my lord.
The thing is that they are, the petitioners out there would be now, earlier when they were sitting in a silver mine, now it has become golden, and with the help of the circle officer, it may be a platinum.
Lordship will make some observations in my lord today's order, my lord. We will communicate it. Lordship will make a stricter, my lord, to the district.
Pursuant to the order dated 19/1/2024, Mr. B. Gogoi, the legal counsel appearing on behalf of the Health and Family Welfare Department, had submitted that the amount of rupees 9 lakh 91,374.82 have been duly deposited with the District Commissioner, Kamrup Metro. Under such circumstances, this court directs the District Commissioner, Kamrup Metro, to take appropriate steps within a period of 15 days from today for disbursing the said amount if not already made. Further to that, this court directs the District Commissioner, Kamrup Metro, to give a status report as regards the acquisition proposal which have been duly submitted by the Circle Officer, Guwahati or Dispur Revenue Circle, as regards the acquisition of the land in question, land of the petitioners in question. The state status report is submitted before this court on 7th of February.
Liberty to apply for release of the amount.
I've already directed them to disburse. You want to release, you give us copy of this order and do whatever you say.
Apply.
Seven.
May I please, sir?
Yes,
My lord, related to land acquisition and compensation. Kindly see the order that.
My lord, I am sorry, my lord. It appears that last order inadvertently, my lord, was not communicated by our officer. Order
the
dated
Talukdar learned on instruction that the process for sanctioning and disbursing the amount of compensation is under active consideration of Viman and some time would be required. List the matter.
I'll prefer some more time.
Mr. B.J. Talukdar, the learned senior counsel, appearing on behalf of the, they are paying for the revenue or district?
No, not.
Appearing on behalf of the district commissioner, which one? District commissioner? Huh? Kamrup Metro.
Not Metro.
Kamrup submits that the order dated 8/12/2023 was inadvertently not placed before the authorities concerned, and as such, the instructions which have been sought for by the said order could not be obtained. He, however, submits that in a week's time he would be obtaining the said instruction. Accordingly, list the matter again on 2nd of February 2024, on which date Mr. B.J. Talukdar, the learned counsel, shall apprise this court as regards the finalization of the process pertaining to sanctioning and disbursement of the amount to the petitioner.
51.
Yes.
The matter is to non-payment of contractor bill. Yeah. Person to work order of 91.
Non-payment of contractual bill.
Yes.
The problem is the animal husbandry is never represented, na? You can't help it.
Mr. B.
Huh? Miss M.M. Kotoki.
MM Kotoki is not sitting. MM
She's not there. She's the animal husbandry. Oh yes, this matter. In fact, I told her that day also when she appeared in another matter. This is pertaining to that LOC scam.
Yes,
na?
yes.
You were out. So there was nothing out there against you. So you are entitled. This amount was withheld.
Yes.
Remember. Is her name shown in the cost?
No.
Not shown.
The name of it.
Lahore. The matter upon being taken up, none has appeared on behalf of the Animal Husbandry and Veterinary Department. it is also seen that on the earlier occasion on 8/1/2000, that is on 8/1/2024, the standing counsel for the Animal Husbandry and Veterinary Department was not represented. This shows very poorly on the said department in not being represented in spite of the fact that they have a standing counsel. Accordingly, this court directs the registry to serve accordingly. This court fixes the matter again on 7th of February 2024. A copy of the instant order be served upon Mr. D. Nath by the registry so that the said order can be placed before the commissioner and secretary. Do they have a commissioner and secretary? Before the secretary to the government of Assam, Animal Husbandry and Veterinary Department, so that the said official can take appropriate steps for so the said department official can take appropriate steps for representation of the said department before this court on the next date, along with instructions. List the court. Yes.
My lord, I have protected RCC building with taking due permission from the GMC.
Then?
And thereafter, lordship, also the GMC had issued a notice under section 239 of the GMC and demolished my wall. But whereas no opportunity proposed was given, nothing else.
Huh?
Notice was issued under section.
What are you challenging?
Inform notice, lordship.
15/3/2018. Where is that?
That is page lordship.
Huh?
Page.
You are there.
Yes, I am praying for some application matter.
Why?
2018 matter, we did not have the file. Next
You are
week,
GMC.
file.
Then? It's a 2018 matter.
Another set of answers
Then what is your problem?
do not have the brief file.
What is this jurisdiction under 239?
There is no jurisdiction, lordship, because it was not issued by the commissioner. 239 provides lordship, the notice will be issued by the commissioner. Here, lordship, at the bottom will show the commissioner, for commissioner.
It's okay. I am not on that. On GMT. You have the permission to construct the boundary wall?
Huh?
You have the permission to construct the boundary wall?
I had submitted the plan, lordship.
No, no. Do you have the permission?
The permission was along with the building.
No. Show me the building permission. Where is it?
Separately, lordship, it was not taken, but it was shown in the drawing.
Mr. Roy, where is the permission for construction
Yes,
of the building
permission
wall?
For construction of wall, it is not there, lordship.
Yes,
Not
your permission. Then permission is there already. You have not taken the permission for
So that is
construction
the
of the building wall.
notice of the respondent, lordship.
What?
the case of the respondent is this, that I had constructed the boundary wall over a government land, drain. That is there.
No, here you are, no, the unauthorized construction over the stormwater indicated in the schedules below within the Guwahati municipal area contravention and rate. Whereas this act of unauthorized resulting in blockade of the event storm has resulted in hazard to life, property and inconvenience to the general public.
There is no storm drain. There is no even any drain over by the side of my land.
But you don't have the permission to construct.
If I had, then the notice ought to be issued under section 337 of
Huh?
CFA. Lordship, if I had no construction for the permission for construction of the boundary wall lot, and then they had to issue the notice under section 337 of the GMC Act. That they have not done. On a complaint lodged by my neighbor Lordship, simply just issued the notice, and after demolition they had served the notice too. No opportunity was given for so forth.
So you want the so called?
Yes.
Your wall has been demolished.
Partly it has been. On 19-3 Lordship, the team came and started to demolish without serving any even 239, section 239. After demolition of the part wall Lordship, they had served the notice, improved notice too. Because the notice is dated 19-3 and demolition was done on the same day. And Lord, to be pleased to peruse the notice, page 57, most vague notice, Lord.
Yes, circle officer. This the land wherein this drain is constructed, is it in the stormwater stormwater drain? That's the only issue. Get your instructions out there. We'll have it on fifth.
I do not have a copy of it.
I think the circle officer is a party.
So circle officer is not a
Huh?
circle officer is not. Parties are Lordship, the
Oh, no.
Commissioner, GMC.
No. Only yes.
Circle officer is not made a party. But the circle officer's report shows that your land, you are constructing over the government land.
There is no drain at all. I have in my activity in reply, I have especially stated
What is this at page 16, page 56? There's a
That-
drain
that
out
is
there.
That is allegation of the GMC.
No, that is your document. Page 56, annexure 16. If there's a drain out there, you cannot.
56 is the photographer.
Yes, that is the drain going out there. Isn't this the drain?
There is no drainage for whether it can be called a stormwater drain lot. There is no drain. I have stated even there is no even a kacha drain. I have annexed the cadastral map also along with my affidavit.
No, you show the permission for boundary. Boundary wall, what permission you have constructed, you show the permission for boundary wall. Otherwise, we have no other.
I have annexed.
Show me the permission for boundary wall.
So that is not the allegation of the GMC lordship that I have.
Mr. Roy, show me the permission for the boundary wall. I give you time, file an additional affidavit, bringing on record the boundary wall permission. Because for boundary wall, also you require permission. Your permission is only for the house.
House lordship, but there is no allegation that I have constructed boundary wall over the government land lordship. So I have constructed boundary wall without any permission. That is not, they have not issued anything. In that event, lordship, the notice is to be issued under the 337 Act lordship of the GMC.
Whatever may be.
They have issued the
As of
notice
now,
under section
you-
239.
Mr. Roy, is what is to issue a writ in the nature of tertiary. It may not interfere with the order or the issuance of any notice if this court is not satisfied. Show me a permission as regards the boundary wall. Why should I issue a writ?
Lordship, I have to take inspection.
That is why I am giving you 7 days time. List the matter again on 29th of January 2024, thereby enabling the petitioner to bring on record the permission obtained for construction of the boundary wall. Full stop. The learned counsel for the GMC shall also apprise this court on the returnable on the next date as to whether the construction so made by the petitioner of the boundary wall is over the stormwater drain.
My lord,
List
in this
recording.
case, my lord, in our affidavit, we have clearly stated, my lord.
I've seen it, but you are not prepared. That is why I'm asking you. Last time you
My
don't
lord,
know. I have already
because
seen
I
you.
can 34 lord. Can it be taken?
Okay, we'll have it on 25th. 25th? Please the matter again on 25/1/2024. Bring it on record that day.
Item 30.
No. We'll take it away too.
No, lordship.
Regarding reservation of the post of president of for women in
Oh,
Nalbari,
that one.
Nalbari Jilla. 5 years are already over, but whether they have issued any notification for election or not, may not know.
Not notification also. I think the period is 5 years.
5.
Now the question does not remain. This issue would remain now.
Yeah.
I close it with liberty to approach at a later stage if this. I think that is a better option. Because as of now, the 5 years is over.
Over.
So the term being over, the question of you being appointed does not arise when the
Definitely.
body is not there.
Definitely.
So
But
I'll give you the liberty, keeping the question open.
But what happened with her? That the government has also filed one affidavit. That 2 terms, there was women. In fact, because for the last term, it should have been reserved for only women.
Understood. I understand. Now, the period being over, the question I'll keep it open. The question which have been raised in the petition pertaining to the reservation of women in terms with Article
78 of the Assam Panchayat Act.
78. of the Assam of the Act of 1994 is kept. I'll keep it open. I think that is the way. Now the period is of the municipal. It's a what is that? Of the Jilla Parishad. No?
Nalbari Jilla Parishad. Nalbari Jilla.
It has been submitted at the bar that the term of the Nalbari Jilla Parishad is over, taking into account section
7.
Jilla Parishad is what? Taking into account section 68 of the Assam Panchayat Act 1994. Inasmuch as 5 years have already elapsed from the date of holding of the first meeting.
It's going to be sometime in February.
February.
Page 27 if you want to. 14 to 2019, the first meeting was. 14 years. 27.
Page
27.
27. 5 to 19.
Then we'll have it, let us have it after this. Then we'll close it. Because deciding this today and giving you a right would be more detrimental to you.
That's why my your lordship has kept it open for today.
That is and list the matter again on 12th of February 2024 for further consideration.
Public.
May I please the lordship? Our last order, lordship already directed to the respondent to obtain a report, lordship, from the Thakur of Chapel.
And with the earlier inspection,
yes.
When the earlier inspection was that the acquisition was not done in respect of this guy. And lordship wanted to know the name. It's in the name of the petition.
Taking into account the above, this court therefore direct the additional district commissioner L.A. Durha to file an affidavit before this court categorically taking a stand as to whether dark number 2 of Patra number 35 created data was acquired by the revenue authority at any point in time. Further to that, the to submit a report as to whose name the state land at present stand, and the state shall be affidavit filed.
Evidently,
So it is in the name of the petitioner.
it was never.
No, was it acquired?
No, that was the earlier instruction.
Earlier instruction was not. Otherwise, why will I ask? You said earlier that you don't have papers or something
Don't
like
have papers and
wherein it has been mentioned that as regards the communication issued by the government of Nepal for purpose of extension, we have no record to be traced. It is also mentioned in the instruction that the land measuring so and so as demand have not been acquired for purpose of extension of land so and it has however been mentioned that the office has no records regarding acquisition of land for railway
no
department.
record.
Now that is the reason.
Right.
Now what that is why you see the railway do not acquire under the Railways Act.
Right.
These acquisitions are done under the by the state. and then handed over to the
Mhm.
railway. So that is why this court specifically asked you as to whether you have anything as regards the railway department. No record acquisition for the railway department. So that was not there on the last year. I have no records regarding acquisition.
that
That
was
is
there.
why I asked you to file an affidavit. File your affidavit.
Fine.
This court, by an order dated 29/11/2023, had directed the additional deputy commissioner, district commissioner, bracket LA Jorhat, to file an affidavit. However, the said affidavit has not been filed. On the other hand, Mr. B.J. Talukdar, the learned counsel appearing on behalf of the district commissioner, the LA Jorhat, district commissioner Jorhat had submitted that the land in question still stands in the name of the petitioner in the revenue records. This court therefore directs the additional deputy commissioner LA Jorhat to file the affidavit as directed earlier in its order dated in the order dated 29/11/2023. On or before 9th of February 2024. List the matter again on 13th of February 2024. This time you file it, else I'm going to call the additional deputy commissioner. Yes. What is this matter about? None appears on behalf of the petitioner on call. Taking into account the above, the matter stands adjourned to be listed. Oh yes, you are there. Tell me. Huh? You do one thing. I'll put your name. The petitioner is represented. And seeks for a short accommodation. This is the matter again on 2nd of February 2024. By that time, you catch hold of your breath. Yeah. 26. Yes, Mr.
Sir,
Dasu.
in this case, they have filed an affidavit day before yesterday. Copy has been filed on me, sir. Some day my file be answered. Probably the affidavit is not your the record. On Friday, probably they have filed.
Yes.
Huh?
Right.
Mr. A. Dasgupta, the learned counsel, senior counsel appearing on behalf of the petitioner, submits that the government has filed an affidavit. However, the said affidavit is not on record. The learned counsel, senior counsel seeks for an accommodation of filing a reply. This is the matter again on 16th of February 2024. The reply, Penny, be submitted on or before 13th of February 2024. 57. You filed the affidavit?
My lord.
Yes, what is your case?
But in this case, this petitioner, your lordship, they are indigenous landless persons, your lordship, and they are in possession of about 70 acres of land, your lordship. And in the year 2014, your lordship, annexure 2, page number 24, they made a joint petition to the settlement authority, claiming settlement of the land in their favor since they are landless persons. That is at page number 24, your lordship.
There was a direction to complete area within 6 months.
That is not in our case.
Huh?
It is in this respect of different case, your lordship.
Okay, then
So an application was filed. After that, your lordship, the settlement of asked the authority to inquire into the matter and send a report. Accordingly, a report is submitted to the 3, page 25.
no, what do you want
Yes,
in your
lordship,
petition?
just come. Connected 3, page 25.
The Lord settle the land in their favor, which are in lawful possession of dark number 12, should not be directing the response to consider the representation. What is your stand? Yes, madam, what is your stand?
My lord, we have stated, my lord, that as per direction of the honorable court, my lord, we have given the hearing and all, my lord. And the annexure last but one annexure, my lord, page 67, annexure. Here, my lord, now, my lord, the subdivisional officer has written to the director of land records and survey that to depute a survey team to the office to alias to conduct a joint survey of land located at Kitishara Tea Estate for disposal of estates. The deputed survey team may kindly be directed to report, my lord, that now then they
Yes, what is your right to remain in possession?
But we are a landless person, your lordship.
Ah.
And we are staying there for about 70, 80 years, lordship. And this affects
Staying where?
lordship,
Staying where?
staying in the sitting surplus land, your lordship.
Ceiling surplus land. How are you staying in the ceiling surplus land for 70, 80 years when the law has only come in 1956?
No.
Tell me.
Subsequently, it has sitting surplus land act has come and that land has been notified to be a sitting surplus land. But
So it can't be, and the statements were prepared sometime in 1971. Then how can you be there in a ceiling surplus for 70, 80 years?
so, your lordship, when they made the representation,
Then
authority made an inquiry, your lordship, and found that they are in possession. But they said because of a pendency of a high court case, your petition at this stage we are not considering. That the high court case be decided.
which one?
That order that has been annexed, lordship. So if the lordship finally
856.
lordship.
Then
Their stand was that after inquiry it is found that we are living there by cultivating the land, your lordship. But because of the pendency of the case, they said that we are not going to consider case at this stage. Thereafter, we made an application for impeachment in that petition. So because of that pendency of that case, we are not being, our cases were not considered. After filing of the IA, your lordship, which I have annexed at page 58, the this petitioner in that case, they have filed an affidavit in opposition stating that the land that which we are claiming does not fall within the land that that is under dispute in that petition. And thereafter, your lordship, the petition has already been in thereafter also disposed of your lordship. Now there is no barrier. They may consider our claim as per law, your lordship. Only because of the pendency of the writ petition, it was the case.
But one thing.
Okay.
This was filed when?
In original petition was filed at page 24 in 2014. We have filed it. The year 2014.
And why you are filing it to the, you are to submit it before the deputy commissioner? Isn't that the law? That you are to submit an application before the deputy commissioner? Or has the law changed in the meantime?
We have to
Then if you don't, I think rule 5 of the settlement rules clearly shows to whom it is to be applied. If you don't apply out there, you can very well state all these things and apply. If you don't apply, how will you get help? And representations would not help you.
Application has to.
How to apply? Have they issued you any notice for eviction? No. So better off, why don't you apply as per those schemes now, as per the
Not-
land policy
not
of
yet.
2019,
We'll apply your Lordship, let them consider it.
and then you will consider.
But-
The petitioners herein have filed a writ petition being aggrieved by the inaction on the part of the respondent authorities in not granting allotment of settlement of the land in their favor, wherein they claim to be in lawful in possession for the last many decades. The petitioners have also submitted a representation to the Assistant Settlement Officer on 16/5/2017, which have also been not considered. It is under such circumstances the instant writ petition has been filed. This court have also perused the affidavit in opposition filed by the respondent number 2, wherein it has been mentioned that pursuant to the order passed by this court on 23/2017 in WPC number 856/2013, various steps have been taken for joint survey, and the said aspect is presently going on. Be that as it may, this court also finds it very pertinent to note that for the purpose of applying for allotment public settlement for settlement of the land, the settlement rules categorically emphasize filing applications to the deputy commissioner, the district commission, the deputy commissioner, which, however, admittedly have not been done. I've also heard Mrs. Yudas, the learned additional senior government advocate, who submits that presently the state of Assam has the land of policy of 2019, and as such, if the petitioner wishes to get settlement of the land, the same has to be done in terms with the said land policy of 2019. Taking into account the above, this court therefore disposes of the writ petition, thereby granting liberty to the petitioners to apply in terms with the settlement rules framed under the Assam Land and Revenue Regulation 1886, read with the land policy of 2019. It is made clear that if the petitioners duly apply for the same in the manner prescribed, then the respondent authorities shall duly consider in accordance with law. With the above, the instant petition stands disposed.
Obliged.
59.
Deputy to Lord.
Yes.
My senior is about to appear in this matter, but he's in court number 5 in another matter for time.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation in view of the non-availability of the senior counsel, and accordingly is the matter after 4 weeks.
But there is a partnership.
Urgency, then one has to be urgent. Then you have to argue.
30.
But you
He will be cleared in the one.
pass over for the time being to be taken up at the last item of the day. 5 o'clock?
Me.
Yes, Mr. Manan. Oh, that one.
That one, your
My
lordship
lord-
has directed them to get the instructions
My lord, we
about
have
the
received
money
the
trade.
instruction, my lord, under that bank
Meet,
account
we
has
are
been
appearing
closed.
on behalf of that the money is not presently in the custody of the
To give us an instruction.
Nekma says prior to lodging the money has already been Mr. Sharma appearing on the reference connected whether the money in question has been freezed or kept both in any term. Yes, what did you stand?
My lord, that both the
Honor to
account,
anyone requested the bank authority to pay for keeping of money which belongs to the arrested accused person. Of the bank.
We have already, connector is already been connected by us. Anyway,
So amount has already been taken away. The account amount is not there, although the police has asked the State Bank of India to do so. But in the meantime, the amount has already been gone. Then what to do?
now your lordship, there are two options. But your lord, that day I have submitted the plan regard to swap, SIM swap. This matter is basically on the SIM swapping side. That yesterday also I got a judgment, but that is not of that is of Maharashtra. That is by the Telecom Dispute Settlement Appellate Tribunal, New Delhi, where the same thing has happened. Then the tribunal, in that case, swapping was done by Vodafone, Idea now Vodafone Idea. So there was a direct pay the amount of 8 lakh and all
To that,
by Vodafone.
to Vodafone.
I'll
But
hand
these
over a copy
authorities
of
were that is what the question is. The problem
Yes.
which arises out here is can this go direct Airtel?
No, that is what here your lordship, the tribunal has come to a finding regard to things that's with regard to the act, IT Act, section 43, wherein it has discussed everything and then said that yes, since this was against the policy because KYC has to be verified and the signature and everything has to be verified as per the rules by the concerned network provider. That was not done. Here also it's the same. It was not done.
Have they filed a reply?
The
Airtel?
not a reply, but affidavit has been filed by
Airtel. No, on merits.
Subsequent.
On merits. So why
There
didn't
they say yes, the person this is for Krongyak. It was the swapping was done in Guwahati in one of the Airtel accounts, and there they have given a photograph and other things which were fake, but it was not fake. The I think the Aadhaar card which was given, that was not fake. So that they have admitted that part, your lordship.
Why don't you file a reply bringing on record those things by way of which I can take up?
That I give a short period of time.
No, I have the intention of helping out the petitioner because he cannot be allowed to fight because of some fault being committed by the Airtel authorities or whatever means. But the only thing this court also needs the jurisdiction. For that, you have to show me that yes, they were in fault for which I can give a direction to the Airtel to make the payment. And if, you see, it is a case of a public transaction. And they are doing public function, discharging public functions, and as such, they would be bound by that. So bring on record each aspect of the matter. Thereby, I can sure bit.
Because I can hand over this judgment.
Because that money has
also-
gone.
there was a issue with regard to jurisdiction that because that was in the appellate telecom dispute appellate tribe, but that was dealt with by the court. It was by I think the
This is
chairperson-
done by the Telecom Appellate Court. Because TRAI has that authority to that.
TRAI has done it on the basis. There was the initial order was by the Maharashtra government. The government authority has passed. Case which they came to the trial. The appellate tribunal challenged the order because he doesn't have an authority. Then the court has discussed that such a case. The
Court
authority-
means which court?
The court means this tribunal.
Okay.
So that is there. And the Kerala matter, your lordship, was basically on the same symptom that was given the direction was given against the SBI, directing. Then they have given an option to the SBI get the money from the concert fund.
So how can here the SBI can get the money? Because that would be impossible. Because that will be, you are imposing upon the SBI, because SBI did it as per them. And all this problem arose because of the Airtel.
So they are at fault. That is admittedly there. So lordship, that part, your lordship,
So
once I can bring a
you
short
come up with
affidavit.
an affidavit,
Yes.
bringing into account on the affidavit and bringing into account the discharging of public function.
That I can.
And then only my jurisdiction can be exercised.
Lordship, it is
Because they
some-
have otherwise taken up a plea as regards non-maintainability.
that they have taken in the earlier act.
Understood.
Subsequently,
But
when they
for
filed.
that, you have to bring into aspect, look into those judgments of Ramakrishna Mission, 2019, 20, 1916 SCC or something,
that
and
Ram-
also the 2023 4 SCC, St. Mary's Church. And on the basis of that, and more particularly paragraph number 75 to 1 to 3, try to bring it within. Mr. Y.S. Manan, the learned counsel appearing, Mr. Yudas, the learned counsel, additional senior government advocate appearing on behalf of the respondent state, submitted an instruction issued by the superintendent of police, Kamrup, stating in the alia that the State Bank of India was stating in earlier that the investigating officer of Rongia PS case number 944 of 2010-20 had requested the bank authority to arrange for freezing the bank account number 20366807543 of the State Bank of India and account number 113101021957 of the Canara Bank, which belongs to the arrested person, stating that the entire amount of the petitioner was transferred to those accounts. It was also mentioned that the bank authority accordingly froze both the accounts as requested.
This is with regard to the accused. The second part with regard to correspondence.
The said instruction is kept on record and marked with a letter. Marked with the letter X. This court also directs Mr. Yudas, the learned additional senior government advocate, to furnish a copy of the said instruction to Mr. Y.S. Manan.
This they have.
Already, I have.
Mr. Y.S. Manan, the learned counsel appearing on behalf of petitioner 6, some time to file an affidavit in reply. List the matter again on 12th of February. In the meantime, the affidavit be filed by 8th of February.
Up to you, but
Now,
one thing you
what this say that two accounts were frozen.
those
Now,
are the accused.
Whether accused has been frozen, then whether the money is lying out there in Canara
That
Bank.
they have not stated.
No, they have
That
not
one line you
stated there.
may add to the order.
This court also directs the superintendent of police, Kamrup, Amingam, to apprise this court on the next date as to whether the money which have been transferred to the account of the arrested accused person held in Canara Bank is still frozen. It is still lying in the bank account of the arrested accused person.
So there is one bank, one is the SBI and one is.
So I have given. SBI is yours.
Yes. Yes.
Arrested is of the Canara Bank is there. So whether that money is still lying out.
Much.
And if the money is lying there, then do you think that we should make the Canara Bank, you should make the Canara Bank a party? Think about
Then let them come up with it.
as of now. The Canara Bank is there. Then only this court can direct anything. If the money is lying.
Just let them come up with the instruction. But
May I please?
Hmm.
My lord, the relief sought for in the present.
You have not filed the reply.
My lord, relief sought for in the present decision has already, my lord, provided.
Mr. Your name?
Abil Mondal.
Mr. M.U. Mondal, the learned counsel appearing on behalf of the petitioner submits that the relief which has been sought for in the instant writ petition have been duly provided to the petitioner, for which the petitioner would not like to further press the instant writ petition. Accordingly, the instant writ petition therefore stands closed as it has become infructuous. This is pertaining to what matter? Oh, you got the land.
Yes.
That's all because of that order, I think. 9/10/2023.
Lovely.
32.
For which the petition.
May I speak?
Yes, what is this?
My lord, matter related to acquisition of land. Kindly state the order dated 29/11.
Yes, what is the status of acquisition?
My lord, I have received one letter, my lord, though it is not. My lord, it is in that letter, my lord, it is stated that my lord, circle officer yet to provide the trace map and valuation report of the aforesaid. My lord, it is yet to be. Letter. It states the letter, so it is not that proper.
The instructions which have been sought for by the order dated 29/11/2023. Have not been provided to this court. This court also takes note of that the standing counsel of the PWD is not represented. Taking into account above, list the matter again on 7th of February 2024, on which date the respondent shall apprise this court as regards the status of the acquisition proceedings
But it most of
without fail.
Okay.
Yes,
My lord, they had to file affidavit or actions long back. It is a very minor matter.
huh?
Very minor matter. It is were allotted to us. We have paid the taxes and it is also mitigated in our name.
What were allotted? Oh, land.
Two rooms of Udali Municipal Market.
Ah.
So that were taken due to construction of building, provided the fund by the World Bank. Now our case was that they may take it, but after construction is completed, those should be allotted to us again. Because the rooms are allotted, we were paying revenue, and it is also mutated in our name. So now it is already complete. So very minor matter that they should allot us. That is the good.
We filed the affidavit way back on 22nd of December to the respondent number 5.
Yeah, that is long while ago. And it's the last ever lot.
Yes.
We've already filed an affidavit,
Wait.
on 22nd of December 23 to the respondent number 5. It begins.
Yes, what is the petitioner doing?
My lord, our claim is that can this be based?
No. What are the petitioners doing? What is your vocation? What are you doing? You are a graduate teacher?
Yes.
Yes. What is your business out there to take this government land?
Graduate science teacher.
You resign from there and then take over. You give it to them when they resign. You give an undertaking that you are going to resign from this job, government job, and then you will be allotted.
Exactly. But this is actually for unemployed students.
Absolutely. What is this? He's a graduate science teacher of Udali High School, and his wife so is working as an assistant teacher at Zakiri so. Here the petitioners are being a government employees and also took undue advantage of obtaining settlement.
No. They are men, they manage the.
No, why do you need? First of all, what is your right to continue for all times? Show me. These are municipal properties or whatever the panchayat properties. What right do you have for all times to come? Do you have a permanent hereditary right? That was only given for 1 year.
Because I was the allotee earlier.
The allotee, what is your right to continue? Show me that you are given a permanent right.
Petitioner also mutated in our name.
Mutation date. These lands do not have. This is to certify that a market plot of waiver has been ordered to transfer in the name of so and so and has expressed his ability to pay the business and other terms related to the land will remain as earlier. It can't go on like this.
There is no bar.
Tax to be paid for transfer of year from 2000 a year. Mr. Mahmood, I think it is better you fight it out in that manner. They will help you up, rather to take the assistance of this court. You may be more successful in getting that betty or whatever may be in those type of manner, not to this court. Because if I pass an order, I'll dismiss it. Dismissing, saying that on what basis it is to be given, which will be more detrimental to you. The thing which you have asked for, you may still be, there is one line out there that you can apply to proper procedure for that. Finally, see, if there is any provision for reallotment of the beti in near future, this may be initiated through proper channel by the undersigned.
Actually, copy of affidavit is not out of us. That's but I am.
Huh?
Copy is not up to us.
No. How is it possible without serving it? Somebody has received it on 22/12/2000 AR for MU Mahmood. Well,
I will get it there.
so what to do? Dismiss?
No. But we take
What instruction?
what your party gave that. Moreover, I have not gone through the affidavit. So if there is any point I find.
How much time does it take? For me, I've just looked into the affidavit now. Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner submits that he may be given some accommodation. And what is this interim order? There is no interim order. Huh? There is no interim order passed in the case. And there is
The room for the purpose of construction.
huh? There is no interim order in the case.
There is no interim order.
Yeah.
No, no.
Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to obtain instruction taking into account the affidavit which have been filed by the Panchayat PNRD department. Is granted 2 weeks time for that. This court have also duly taken note of that in the order dated 18/12/2023, there is inadvertently mentioned that the interim order passed earlier shall continue. However, there on records reveals that there has been no interim order so passed. Under such circumstances, this court clarifies that there is no interim order passed in the instant proceedings. List the matter again on 19th of February 2024.
Fix the matter on 12th of February. Any day thereafter, 15, 16. Senior will not be able to.
Senior is a senior advocate or
Senior advocate.
senior advocate? Then senior advocates have no right. They are daily wagers. So you engage some other senior advocate if you want.
Any other advocate.
Absolutely no. This submission which you have made is absolutely not, cannot be considered by this court. I'm very particular on this aspect. You ask for yourself. Any problem with you, then I would consider, not on the ground of senior advocate. Now, what is your submission?
On any other date.
Why?
Have some difficult.
You have it. Okay. Now fix it on 15. 16. Yes, Mr. You have filed your reply?
No, fine.
Huh? Affidavit in reply filed by the petitioner.
Yes.
Then, what is the case about?
It's about Lordship, the Naga, I am running a junior college in the name of.
You are running a?
Junior college, Lordship.
Okay.
In Ramanujam Junior College now. So it has constructed G+3 RCC building with due permission from the municipality. thereafter, Lordship, during COVID period, he constructed two upper floor without any permit. Then Lordship, the municipality Lordship issued the purpose notice and demolition notice, against which I filed a appeal under section 296 of the Municipal Act. That appeal has not been disposed of till no date of hearing it. My only grievance is that this is the
Appeal
appellate.
filed before whom?
DC,
Before Deputy Commissioner.
Deputy Commissioner is the appellate.
Then,
He has not done anything, Lordship. No date has been fixed, no matter has not been heard. Then I approach this one.
so that is good.
That may be DC can be disposed of by directing the DC to.
No, my lord, the Deputy Commissioner himself in the charge of chairman at the 11th. Therefore, Deputy Commissioner cannot be the appellate. Same approach. That is my point.
So now we will see that without permission, how did you construct? We demolish it.
Lordship,
Demolish.
they
You had no permission. Then how did you construct?
The
No,
buildings
no,
are there, not
no, the subsequent fact is this, Lordship. My land is
Subsequent fact out there. How can you construct without taking a permission, Mr. Roy?
during Lordship, I had prepared the plan and thereafter I submitted plans for.
Whatever may be, is there a permission, scope of a deemed permission?
Lordship.
Is there a scope of a deemed permission?
I applied for the extension of the fourth and fifth floor for approval. Lord, I have stated in my affidavit.
Then why did you construct?
Lordship, I have admitted my mistake, Lordship.
Then,
But it is a college, Lordship, and
so what?
no,
How does it make that? This is of one Dilip Kumar Bora. Who is he?
he is the secretary of
Then there's nothing
principal
wrong with
cum
it.
secretary. Lordship, my area of land
Where is
is
the order of demolition?
order of demolition is Lordship. Page 47.
Page
47.
No, there are two. One is at page 58. What is
Yes,
that?
yes.
The buildings are there.
Huh?
The
It's the
buildings,
same
they-
thing. Oh, no. You are hereby directed to remove the unauthorized demand, failing which will you constrain to demolish the aforesaid unauthorized construction made by. Eh? You don't have a permission. That ends.
Lordship, my land is measuring more than 1 bigha 2 kathas.
So what?
I am entitled to get the
Oh,
further
so
FIR.
then should we
Further
make a, Mr. Roy, should we make the law out there to the effect that if the otherwise it is permissible, no permission is required? Go and ask for amendment of that act. We couldn't have constructed this.
Already I have applied for a
So what?
regularization of fourth and fifth.
How can there be a regularization of floors? Is it permissible? Show me. Is it permissible? For regularization of floors, it is not permissible.
Petitioner is entitled to further FIR. He has a right to construct. but
Mr. Roy,
permission.
Mr. Roy, is it permissible for regularization of floors? No. The answer is a no. You can't help it.
So Lordship, then what will happen to my right to appeal?
Right to appeal is not there. That is why you have come. Go and be happy with the appeal. Why should I?
Same authority. Same authority. The authority which has passed the demolition order.
This court is taking up your matter. If there is no appellate authority, just similar to the land grabbing, there is no appellate authority. This court is taking up.
It should provide
to
for
do
the
this-
provision of appeal, Lordship.
Huh?
It should provide under section 296 filing of appeal. The municipal board was superseded by the government.
So the DC has passed the order.
No, nothing, Lord.
Executive officer passed the order. With the approval
Executive
of the
officer passed the order.
the approval
Demolition
of the
notice
DC.
is to be issued only by the approval of the board, Lord. Executive officer does not have any power, Lord.
You show me on the law, forget about other thing, as to whether you could have constructed 2 floors without permission.
Sir, I am admitting, I have admitted in my petition also, Lord.
Then the matter ends. 2021, I think you have enjoyed 3 years with that floor.
So Lordship,
How much time will you take to demolish it? 30 days?
If your lordship dismiss the petition, then they within very short period of time, then
No, you ask them money also.
I am ready to pay
that
any
cannot be
penalty.
done. That cannot be
No,
done.
no, demolishing, after that, the amount,
Yes.
the expenses for that.
There is provision also for that.
Hmm.
Lordship, would you please to consider that
I
am
have nothing to
entitled for
consider.
further
No,
FIR.
Mr. Roy.
I
It
had
is-
applied before the municipal board for
So what?
regularization of fourth and
When did you apply?
I applied Lordship.
No
please to
application
take up
being filed. Michael.
additional
If there is no application being filed.
Let us see, when did you
They-
apply?
they- so they- we
No,
will
wait,
file.
wait, let us see, when did he apply?
Yes. I applied Lordship. Yeah. Yes. Your Lordship, will please to take up my additional affidavit. I applied on 29th of September 21.
29th of September 21.
Now, I have annexed all those relevant.
Wait. 29th of September 21.
20.
You applied.
Yes.
And when was the impugn order passed on 3rd of September 2021?
20.
Then you, after constructing, you applied.
Yes, sir.
Then
For
how is it
regularization-
possible?
For regularization.
There's no regularization. Show me the provision that it can be, floors can be regularized. Show me that.
Lordship, but owner is-
Mr. Roy, this type of submission would not work. Kindly show me a law to that effect. That many other aspects, regularizations are permissible. Just for example, certain aspects as regards 10% FAR is permissible. These are certain, but floors are not permissible. And you applied after filing the writ.
Lordship, under the notified area, the rules 2014, Lordship, for the, except from Guwahati Municipal Corporation, the regularization provision is there.
Sorry.
The Lordship, even the Municipal Act, Lordship, there is a provision.
Show me that.
Section 177, Lord.
Yes.
Section 177.
177. Yes.
Second proviso, Lordship, provided also that the board at a meeting may, instead of requiring alternation or demolition of any such building, except by way of proposition, such some age may. So under this provision, Lordship, I have applied for regularization of the architect. Because Lordship, I am entitled to construct up to 6 floors as per the area of the land. My area of the land is more than 1 bigha 2 kathar. So they should reject my regularization application or allow it.
You filed it after that. You submitted that document after that, not prior to this.
But Lordship, the section 177 second proviso provides clearly that the board at a meeting, instead of requiring alteration, demolition of any such building, except by way of proposition such sum, it may deem reasonable. I am ready to pay the composition fees, Lordship. When there is a statutory provision, that right cannot be taken away. Then they should reject.
Mr. Khan, do you have a bylaw?
There is zoning regulation, Your Honor,
Ah.
or Your Lordship. Under Rule 9 of zoning regulation, I may be allowed to read it. Compoundable item.
Ah.
Coverage maximum 15%. FAR maximum of 10%. Setback up to 2 feet 6 inches. Open space maximum 10% reduction. Total height of building 1.5%. Non-compoundable item. That cannot be regularized.
That rules
You-
will apply, Lordship, in case of deviation, Lordship. Here, Lordship,
Yeah,
is the case.
Let me finish.
Then let him.
Sorry.
First, use of building. Second, addition of extra floor. That's it.
This is same to with the GMC.
Exactly. Exactly. Another interesting point here, my lord. Can you go to the prayer portion?
Hmm.
In prayer portion, your lordship will find that the notices which they have prayed for quashing are only chokers.
Are?
Chokers notices, not demolition. Annexure 5.
And you have not challenged the 39.
Annexure 5, Annexure 8, and Annexure 11. These are so
Well, they have not challenged this page 58. Page 58 and page 47, they have not challenged that.
and they have responded to those chokers notices.
Hello. You give me that zoning regulation. Yeah. Okay, I'll dismiss it.
It can be, my lord, also dispose of giving a direction to the
Dismiss.
board.
It cannot be.
to
I will
consider
make
my-
it clear that the proviso has to be read with this penalty.
Lordship, my submission is this, if the section 177 is. the
You, I think
substantive
the
law.
division bench will understand more on this, not me.
Rules are not the subject.
Yes. Dismissed.
And when Lordship, the executive officer, after supervision of the municipal board, does not have any power to issue any demolition notice, because the power vests after supervision with the DC. Already my learned friend has submitted that the power of the chairman or the board is being exercised.
But
by
you have
the-
not challenged. Mr. Roy, you have not challenged 3/9/2011-21. See your petition. You have not challenged that. How can you make that
is,
argument?
Lordship, I may be given an opportunity to amend
Sorry,
the petition.
those are there in division bench.
Only that 100% that has been installation part. And secondly, my lord, the annexure 8 is under silence, my lord, regarding 50 feet, my lord. That has been, my lord, affidavit not reflected, my lord. So, my lord, I also want to file, my lord, counter to the affidavit, my lord. And the annexure 8, my lord, is the under silence, my lord. Based contract. That has been not, my lord, reflected in the way, my lord, the affidavit, my lord. Paragraph 11.
Now, what is your grievance now? You have received the money?
My lord, money we have received, my lord.
Then what is your grievance?
Only thing is that, my lord, the Girard part, my lord. So Girard part, whatever the calculation, my lord, that part has to be different. There is no solution.
Huh?
100% solution has to be given, my lord.
So this is done under you go and approach the authority, file an application under 3G.
Statutory component, my lord. It is statutory component. We are not, my lord. We have no grievance that they have assessment is, my lord, something wrong or we are expecting more. It is statutory. Whatever they have given Girard, 1 rupee they have to plus 1 rupee. That is statutory component, my lord. That's to give them, my lord.
So how can this court,
cannot be both
how can this court ask them to redetermine that?
Report can my interfere in this matter.
No.
Anyway, my lord, I'll file, my lord.
What is there to file? The matter is over. You are, if you have any, they are to kindly apply
that's
before the authority.
50 feet, my lord. That is, my lord, still, my lord. They have not addressed on this issue, my lord.
Huh?
That annexure 8, my lord.
Yes.
Annexure 8, my lord. Then we'll file one counter.
You will file what?
Counter, man. Regarding this, my lord. 50 feet and this, my lord. Regarding, my lord. Girard, my lord. Solution of the Girard.
So, if you are not being given, why you are spoiling the time out here? At the end of the day, you will have to go there. Mr. Soronia, kindly appreciate one thing.
Right?
You kindly appreciate one thing. The more is the delay, you are losing on the interest.
Hardly within 1 week, I'll file, my lord.
No, it's not that. The thing is, on the other hand, tomorrow the matter will again go out there. The matter has to go.
But, my lord, the annexure 8 will remain, my lord, until the court decides, my lord. Because here, my lord,
Annexure 8, what does it say?
My lord, may I read, my lord? The authority of Karbi Anglong Autonomous Council, DIPU, is pleased to notify the henceforth the roadside reservation of the land in respect of NH 29 under the jurisdiction of Karbi Anglong Autonomous Council will be 50 feet in either side of the road from the center line and existing national highway from the Parakwa to Lahorida. That means, my lord, if 50 feet, my lord, earlier the road was, my lord, state road. That has become a, my lord, national have taken, my lord. There is no, my lord, acquisition of land, my lord. So, whatever the state government PWD road, my lord, that is existing, that is, now they have, my lord, acquisition the land, my lord. So, road 50 feet is not coming under
Acquisition of
not
which
taken,
land?
which are been, my lord, acquired, my lord.
Which document you are referring to? 8?
Page 132, my lord, Annexure 8.
Yes. Is pleased to notify the henceforth the roadside reservation of land in respect of NH under the jurisdiction of area will be 50 feet on either side of the road from the center line of the existing area from so and so to so and so. Then
And that has been not addressed, but that is under.
now have they acquired this land?
My lord,
Then
no, that land has been not acquired, my lord. Which 50 feet they have said that earlier it is in, my lord, land acquired by the authority, my lord. That has been not acquired. That has been, our land has been taken up, my lord, without accessing those 50 feet, my lord, either side. And not 50 feet, 20 feet, my lord. If, my lord, this is under silence, this, my lord, goes in, we will get, my lord, 20 feet more, my lord, than bill. Only after acquiring, after notice, they have issued this notice.
now this thing of 50 feet which have been done as reserved. No, this reservation is only, it doesn't become a government land. This land, what happens normally, if you get a patta, you'll see that 15 or 20 feet is always reserved.
Well,
So that
66.
tomorrow, the government can acquire that. You may have to forfeit that area subject payment of compensation. This is what the reservation is made. That tomorrow, what happens, this 50 feet on this side or that side, if you are there, that land will be acquired and you will be given the compensation for that. But as of now, they have already made the reservation. If you see the pattas,
Yes,
normally whenever you are given a patta
Yes.
in your land,
Is 66. Is 66 of the repetition. Patta is there, condition is there.
it will
Page
always be
66,
there.
para 5.
This is always there.
Always there. Page 66, para 5. The provincial government or official of government shall have the right to collect art within 35 feet. They have the English translation. It is the Assamese version. There 35 feet. Man.
They're paying only compensation for rural area. Now, this is earlier there, 35 feet.
35
Now,
feet.
nowadays, this will be, roadside reservation will be 50 feet. The land will be yours.
My lord, not to use, my lord, just to collect the art, my lord, not to language, my lord.
Whatever may be, they have to acquire it. That land has to be acquired. This might be
They
a
have not
term.
acquired, my lord, that is, they have not acquired.
They will not acquire now. Tomorrow, another 50 years from now, they may want to make it, which is now 2 lane, 4 lane, they may think of making it 8 lane.
My lord, they,
Then only this will happen.
now the road is, my lord, 150. Either side, both sides, my lord, 75, 75.
Understood. Tomorrow they may think of having it 250. Then they may have to take this 50 feet, 50 feet. Then that will be the reservation. As of now, that land will be yours. There's no quarrel with that. The land will be yours. Only the fact is, the land will be, at one point of time, if they acquire, they will be acquiring like as roadside reserve. That is not your land. That is not their government land. They would never acquire these 50 feet on both sides. Isn't it, Mr. Swetia?
My lord, they have to clarify, my, but they have to clarify.
Well, regarding 35 feet, earlier it was 35 feet from the side of the road.
Road.
Now they are, this circular, it was made for the middle of the road.
From the mid.
Earlier was earlier 35 feet. So only the 15 feet, otherwise it will go 35 down to 20 feet, my lord. So they will not get the compensation, my lord, for their benefit, petitioner benefit. Yeah, the petitioner got the benefit of compensation more than 20 feet, my lord, by virtue of this notification. It is the, my lord, the earlier it was the 35 feet, they are
From the side of the road.
side of the road. Now they are making it the middle of the road. That means the earlier road was 35 feet. So 17.5 feet is there. That is the thing, but I'll file an affidavit, madam.
Who?
Because
I do one thing.
what I have
No,
understood,
Mr.
madam, maybe
Mr.
my-
Saronia, you can do whatever you like. I'll issue rule. Let this matter come after 10 years. In the meantime, be happy.
In a motion stage
You
of lordship-
lose tomorrow.
in
You
a
don't
motion
understand
stage of
what I'm
lordship-
saying.
In a motion stage of lordship, observe that one.
This is the matter which is going to
My lord.
happen tomorrow.
No, my lord,
You
my
will be
understanding
losing
is
out.
that, my lord, they have already, my lord, 50 feet, they have demarcated the earlier road, my lord. That is earlier 55. Now they have paid only to, my lord, 15 feet to us.
Yes, that is why they are paying you 15 feet.
Earlier 50 feet not belong to the people, they have not acquired. This is our land, my lord. Whatever they have acquired, my lord, earlier, they have state PWD road, my lord. Let them, my lord, bring the record of the state PWD, my lord, that this is the earlier road, this is after the national highway, this portion has been acquired. Then total breadth of the road is this much. Then we'll
Now,
satisfy,
are
my
you
lord.
saying that your area
My-
is much more which have been acquired by them and
Yes.
not paid the compensation? Then why don't you go under 3H?
Because of this, they have said 50 feet either side.
So you go under
Their road was
3H.
60 foot either, that's 100
How
feet,
can
my
this
lord.
court decide?
Only they have paid the excess,
No,
my lord.
Mr. Soronia, how can this court decide? Tell me.
Under what?
You
provision they
want
have-
this court
my
to
lord,
go there?
unless they have not acquired, under what provision they have acquired. If they have acquired, they can show that has been already acquired. The 50 feet also, my lord, they have, they are utilized by my lord acquisition. Let them show, then we have no answer, my lord, then. Let them, my lord, justify.
Where's the 3D notification?
It is notification, my lord.
It's 103.
106 of the petition?
Petition.
3D.
3D.
Okay.
And one is they have enacted as case 81 also. There are two 3D notes and they have enacted different portion.
But is it 3A
Yeah, 3D, my lord. There are two
or
3D,
3D?
3D, different section, my lord.
Except here, 5. 4, 5.
First was in page 81, that is the distance from 65 to kilometer 80, 3D notification, and page 106 relates to kilometer 80 to 96.
Here the stretch of land is from 65
5 to 80, my lord.
to 65 plus 923 to 80 plus
930,
930.
my lord. And the 106 is, my lord, page 106, notification dated 12 July 2021 relates to 80 plus 930 to kilometer 96 plus 4. To different notification, different portion of land.
And the petitioner's names are here.
My lord, section 4, my lord, that is a schedule. If you look into lordship schedule, section 4, petitioner's name is, my lord,
Serial number?
page 115. The different person, my lord, page 111, 110, my lord, from it starts from 110.
Yes.
Serial number 127, his petitioner number 29. Serial number, village number 1, Madarkha Pathar. Serial number 127, Narendra Nath Musahari, petitioner number 29. 128, petitioner number 32. Serial number 129, petitioner number 3. Like that, my lord. 131, petitioner number
So
25.
everybody's names are here.
Here, my lord.
So your acquisition will be limited to the 3D notification.
3D notification, my lord. And if you have any grievances, it has already passed the order in other cases also to approach the arbitrator, my lord. That is another point for the
In that,
appointment
my
of
lord, that
arbitrator.
notification is not under. That notification is not under arbitration.
And if you have any grievances under 3ST, he can approach the district judge also, my lord.
My lord, that issue, my lord, I have understood.
Regarding, my
In
lord,
case of this, my lord, they have said that we are not entitled in it. They have said that the 100 feet road is existing road. Here cannot be question.
I am not on anything else. Here the simple question is you have already acquired this land. Their acquisition would be, or your rights which have been acquired will be only limited in terms of the 3D notification. That's all.
My lord,
The acquisition of your land will be only limited to the 3D notification, nothing beyond that.
my lord, that in case of my lord, whatever my lord compensation, but we are saying that you have acquired more land, but which has not been shown in the here, my lord, as per this annexure 8, my lord.
Show me which land they have acquired. More land.
Because my lord,
No, you are telling me, show me which land. We are to see on affidavits. Now show me which land you are saying are acquired beyond what is there in 3D. Show me that.
then we will file the affidavit, my lord, that part, file it.
Issue rule making it return of issue this court upon hearing the matter and having taken note of that the pleadings are complete, admits the writ petition. So issue rule, list the matter for hearing in the first week of April 2024. In time, the petitioners in the meantime would be at liberty to file any reply.
Hello.
In the month of April, this before hearing in the month of April.
Item 38 and 39 for orders.
Any? Oh, no. Yes, what is this?
May the petitioner kindly tell the order dated, my lord, 6/11/23, my lord.
Yes, under what establishment?
They have filed an affidavit, my lord, but they were
10,000 rupees.
We have filed an affidavit. My lord may be pleased to come to running case number 88. From that, my lord, the affidavit starts.
Yes.
And the background has been precisely stated, my lord, from paragraph 4 onward. So you may be pleased to come directly to paragraph 5. The process started, my lord, way back in the year 1984. One circular was issued, whereby, my lord, at the royalty at the rate of rupees 2.5 per cubic meter of brick earth and also enumerated certain terms that we have annexed, my lord, at annexer A. That my lord will find at page 97. This was the first, my lord, circular issued by the Revenue Department.
Is this land leased out?
Pataland, man. Pataland. No, Pataland, this is with regard to, my lord, extraction of rupees 10,000. We are now concerned with only these grievances. How come 10,000 be expected from us? Now, this is the background history. Finally, at page 104, page 104, annexure D.
Yeah.
This, my lord, circular was issued. Settlement of land for brick clean, so and so. Here, my lord, Rocky will kindly come to the first, second, third paragraph, royalty. A minimum rate of rupees 12,000 per year shall be paid as royalty for producing brick up to 4 lakh number per year and additional amount of so and so, so and so. So these were the, my lord, conditions issued. Several conditions were issued, my lord. Then page 105. Now thereafter, my lord, this circular was put to challenge.
Yeah.
This circular was put to challenge before this honorable court. Lordship may kindly directly come to page 109, annexure F. Now there was a consensus arrived at between the government and, my lord, the Brick Clean Owners Association of the entire state of Assam. And they have arrived at a consensus, my lord, that and they have agreed to pay, my lord, rupees 10,000 per year royalty instead of rupees 25,000, my lord, per year. And, my lord, this is how, my lord.
Are you a member of this Assam, all Assam Brickfield Owners?
That inspection I have to obtain. That inspection I have to obtain.
What is there to obtain? You cannot operate without and this affidavit was filed long time back.
Yes.
Then 29th of November, you have to obtain instructions.
I could not contact matter.
So they are not interested with this 10,000.
No, they are interested matter.
They are not. When there is already an agreement out here, go and file an application before that the division bench out there for saying that you are not a part of it and as such you cannot be made a.
Because, my lord, I'm not argument made today, my lord. I'm not fully prepared to argument to the case, my lord.
What?
I'm not fully prepared to argue the case today, my lord.
What is there to fully prepare?
I'm just guessing that because Lordship has asked them the authority. Under what authority of law, my lord?
The authority is already, rightly or wrongly, they have done and you have duly accepted that.
My lord, that is why, my lord, Lordship may take up tomorrow, Monday, my lord. Just I will confirm it, my lord, I was a member or not, my lord. On Monday, Lordship may take up. I just confirm it, my lord. Otherwise, and thereafter, my
This is
lord.
the matter again on 29th of January 2024, on which date the learned counsel for the petitioner shall apprise this court as to whether the petitioner is a member of the All Assam Brickfield Owner Association. Because if you are not, then you are liable to pay 25,000.
Yes. Item number 13 also, direction was given. Item number 39, my lord. Direction was given to file affidavit, my lord. In that item.
Not necessary. We are satisfied with this.
Item, my lord.
First of all, let us go with this.
My lord.
Because now you will be if you are a member, then 10,000, otherwise 25,000.
25,000.
Yeah. You calculate how much additional amount you are left. Yes, anyway.
Pleasure. I'm obliged.
Yes, Mr. Sakia.
So far not paid by them.
Huh?
They know they got long back. In your affidavit, my lord, just that the executive engineer has not released the money. Affidavit I have gone to my lord. Affidavit in opposition. Lord. In paragraph 6, they have made the statement that the money is not released by the executive engineer. Man.
Your land has been acquired.
Acquired, yes, my lord.
Payment not made.
Payment is not made.
Who has not made the payment?
Deputy Commissioner. Man.
Huh?
DC, man.
DC, which one?
Our Kham group, Metro, man. Then was acquired at my lord near Ganesh Guri, along with the building.
Yes, you are paying. Why won't you pay?
My lord, here, my lord, I am appearing for respondent number 1. My lord, he had expired, my lord, on 24th of July 2022, Rajesh Prasad, as he was then. So this is how I stand. And my lord, the matter pertains to my lord that a land acquisition process was initiated, award passed, they were not satisfied with the award. They went for enhancement. The district court, my lord, passed an award enhancing the amount. Thereafter, my lord, since that amount was not disbursed to them, they had filed this writ petition. At the time of disposal of this writ petition, there were materials on record to suggest that some exercise were initiated by the authorities, my lord, for releasing the payment in terms of the refinance code award. Now, to that extent, my lord, this writ petition was disposed, giving my lord liberty, my lord, to the petitioner and also, my lord, a short direction to the respondent that to release the amount as early as possible. But here, my lord, if that reference code order and award, my lord, it is to be deemed as a decree, then, my lord, he has to, my lord, put that, my lord, decree to execution, my lord. Otherwise, my lord, writ petition itself was not maintainable, but nonetheless, my lord, it is my duty to point it out before this honorable
My lord,
court.
the reference case was allowed. It was not dis- My lord, I have annexed it in
I have made my
my
submission.
contemplation,
If
Lordship
you
can
don't follow
receive,
it, I can help it.
Lordship can receive the order of the district does in my contemplation paragraph page 70. And relevant portion will be.
Mr. Arbor Pujari, the learned counsel appearing on behalf learned counsel submits that his client, Sri Rajesh Prasad, had expired on
24th of July 2022.
24th of July 2022. Taking into account the above, the instant contempt proceeding stands dropped insofar as Sri Rajesh Prasad is concerned, as insofar as late Rajesh Prasad is concerned. Now, as regards the others, are these people anywhere there?
Yes, my lord, Deputy Commissioner.
Who is the Deputy Commissioner now?
No, my lord, they have not implemented the new incumbent.
Yes. These are not there.
Who is the new incumbent?
Eh? It is already there in the newspaper. Find it out. Mr. R.C. Sekia, the learned counsel appearing on behalf of the petitioner, submits that you take appropriate steps against the present incumbents.
Then Deputy Commissioner, my lord. But the other.
Mr. Sekia, you need Mr. Sekia. That commissioner and secretary of revenue had died. Are you not required to make somebody? Please the matter.
For implement. For implement.
You have to do something. I can't further instruct you. I may have to go the other side then.
Yes,
Yeah.
41.
I am obliged, my lord.
Obliged. Obliged.
Such a payment has been made.
Payment made. The learned counsel appearing on behalf of the ASTC submits that the payment have been duly deposited before the Motor Accidents Claims Tribunal at Motor Accident Claims Tribunal, Guwahati, on 14/12/2023 and 19/12/2023, taking into account the above. Now, full stop. To that effect, certain instructions, the details have been furnished before the court, which is kept on record at mark the letter X. Taking into account the above, the instant contempt proceeding stands.
May please, your lordship, Lordship, in this matter, the
Okay, none appears on behalf of the petitioner on call. So it is further relevant to take note of that on the earlier occasion, on 21/12/2023, this court had also duly recorded that the petitioner was not represented and had also not taken steps upon the respondent number 6. Taking into account the above, this court makes it appears that the petitioner is no longer interested in the instant proceeding for which the writ petition stands dismissed for non-prosecution. Interim orders, if any, stand vacated.
43. Because abnormal delay is there because of non-appearance of lawyer, my lord. Party was
What is this?
communicating with the lawyer.
Now, what is the matter about?
Matter about, my lord, I was granted permission to construct shop in my
No. What is this IA business?
I have two IAs, one for condemnation of delay and another for registration of the petition, which was dismissed due to default of lawyer.
Then,
This is why. So my humble prayer is this condemnation may kindly be allowed.
how much day?
Writ petition may be reached.
How much?
Delay, my lord, delay is 2,482 days.
Then why should I do it?
Because, my lord, the lawyer was absent, I was communicating with him, he was continuously saying, okay, there is nothing to be worried about. But later on,
Have you filed any application? Have you filed any petition for against him in any forum? Have you filed anything? Then why should we take the as a ground out there?
record, my lord.
No.
It is the dismiss for default.
In fact, the lawyer who has filed these IAs have not been represented on various occasions. Kindly see, the lawyer is not represented on 15/3/2023, 3/5/2023. Then who is the respondents?
Respondents are state bank.
Huh?
On the state,
I appear on behalf of respondent number 3, Lord.
Yes. What is the matter about? Do you have any
Matter, my lord,
objection?
that, the petitioner was constructed in a government land, Lord. It was
Then?
allotted to the, my lord, under the Municipal Development Authority.
Then you demolished it or not?
It was not demolished.
That the matter had come up
My lord,
before.
earlier it was under the, my lord, Development Authority. Now it is under the, my lord, the Municipal Corporate, Municipal Code.
So then?
my lord, my partner friend is not talking properly. Kindly see page 17. If it is governmental, why they have issued permission? Kindly see page 17 of the writ petition. Here application is granted for the above mentioned declaration as per bylaw of the authority. The NOC shall be valid for 1 year to inform the concerned inspector at the time of foundation to make provisions for drainage, sensors. So, if that is government land, then why they issue permission? Now they are coming a new story.
That is not true, my lord. But the petitioner's father's
your
lordship
order.
already been stated, my lord, in the application.
This is your order, not my order. Why you have issued permission? How there is very.
My lord, issue permission is only particular, my lord, his land. My lord,
Yes.
it is not the, my lord, issue, my lord, the
Yes,
permission to the
yes.
government landlord.
Yes, that is true. I told you to want. I also want that. I also
Now,
want
is this a common land?
Lordship.
that. No, it is not competent.
How,
How
lordship, may kindly see.
That show me your land documents.
land documents, my lord, there. Here, everything is there, my lord.
Where?
May I kindly see page 13.
Huh?
Page 13.
It is just from page 12.
If it is your land, obviously you will
Yes,
have pata.
page 11 can you see first. Jamabandi for survey village. Basiruddin
Basiruddin
Ahmed.
Ahmed,
He is my father. Now, it is-
father,
it is-
in respect of 2 bighas, 2
Yes.
kathas, 3
Yes.
acres.
Now, second lordship kindly see the vernacular is page 12 and page 13 is the Moja Nokari Natlakupur Shahar part 2. Name of the Patrata Basiruddin Ahmed. So, vernacular is page 14. Now, my application page 15. Can you see page 15? So, to the chairman, Natlakupur Development Authority, I request you to grant permission for construction of residential building. So all the important, all the requisite materials, permission, which are required for getting permission were submitted. Then the authority was satisfied and granted permission.
Then,
That is page 7.
then,
Now somebody has told them something, I don't know why. Now my submission is this, pilot. I do not want to construct anything over their land,
whose land?
over the government land. I want to construct my construction, that is shop. They have allowed a shop. It is only for shop. So that may be permitted and necessary measurement may be done by computer office. I have no objection. Only by oral submission, how can a permanent right of a periodic patta holder may be taken away?
Impose cost.
Hello?
Cost. You want this matter to be restored, cost.
Yes.
Okay, you pay 10,000. Without cost, this is not possible.
I'll make it 5,000.
10,000. No, it doesn't look like. Because you see, I would have otherwise know, but the thing is the cost has to be paid. It doesn't look like. It has been done so much, such a delay.
Delay.
One has to.
I
If I
understand.
don't give a cost order, it doesn't be fit. Otherwise, you may try your luck on 19th of February.
No, I would not.
You may
Just
try your luck.
changing of pens, the lordship is indicating I don't want this. I was
No, but I am not going to give without the cost of 10,000. 10,000 has to be given. That's a delay. You see, it has to be. You were all along, whatever may be, the lawyer made a mistake, it's okay. So you have not done any, taken any action against.
Even then, my lord, as part of honorable order, they did not, my lord, serve notice, my lord, to my lord, respondent.
No, justice service is there. Service is completed.
Service is completed. Only, my lord, that I has been given, lord. No writ petition has been given to us, my lord, till that.
No, writ petition is not restored. Question doesn't arise.
Even then, my lord, before that, my lord, before that, lord.
No, it's okay. That will be okay. But that is not on there. How many respondents are there? Respondents are there.
Three.
It's okay. For 10,000, huh? Cost. Both the interlocutory applications are taken up for disposal by this common order. IAC 580/2021 is the application under Section 5 of the Limitation Act 1963 for condoning the delay of 2,482 days in filing the restoration application. To WPC number 5101/2006, which was dismissed for default on 10/2/2015. The second application, that is IAC 582/2021, is the application seeking restoration of the writ petition, which was dismissed for default on 10/2/2015. This court had perused the materials on record and is of the opinion that taking into peruse the materials of record and also the writ petition, contents of the writ petition, taking into account the ground which have been taken, that it was on account of the fault of the council which have resulted in dismissal of the writ petition, which have resulted in non-appearance and consequent dismissal of the writ petition, which was also not informed to the petitioner. This court is of the opinion that this is a fit case for restoring the writ petition to the file. This court, however, also cannot be unmindful of the fact that there has been a considerable delay in filing the application, for which this court imposes a cost of rupees 10,000 to be paid, to be deposited in the registry of this court as a condition precedent for the purpose of restoration of the writ petition. The said amount be deposited by 25th of January 2024. Both the interlocutory applications accordingly stands allowed. I main petition not before. Taking into account the order which have been passed in the accompanying interlocutory applications, by which the order dated 2/10/2015 passed by this court have been recalled, and thereby restoring the instant writ petition, lists the matter for admission on 5th of February 2024.
If fail to deposit the amount,
Huh?
if fail to deposit the amount, that is not the Mr.
I hope he
Fighting
deposits.
like a private party, you are fighting like.
Huh?
My learned friend is fighting like a private party, being a government officer. Definitely, because our interest is there.
I think, my lord, that let my friend start up office of the
No, definitely, I will start. That is what the
I
order
don't
is
want to
not-
record that.
But definitely, we will start. For that order is not that.
Yes.
Lordship,
What is this?
This is regarding that appointment of arbitrator.
Hmm.
In fact,
Oh, yes. What has happened in the meantime?
Lordship had asked me to take some instructions if I had talked with them. Now, any appointment or anything like that, any notification, that has to be uploaded in the Bhumi Rashi portal
Ah.
of the state. That's not done. First. Secondly, Lordship, a retired person cannot.
That is my, therefore, my specific question was
Yes.
there. A retired person, it will be
Retired
difficult.
person cannot. And they have not uploaded. And my feedback, Lordship, I have had a talk this afternoon also. As soon as they upload it in the website, immediate action. They are not.
Yes, revenue, what we have to say. Do something on this. No, if this is getting delayed, then we have to entertain all these applications.
That one we have taken second of the computer, they have uploaded.
Yes, Mr. Barbujari, do something on this. On that day also, I have pointed out that aspect. Because, first of all, you see, it can't be a one-man army. One person, arbitrator, you can't entrust with him more than 1,000 matters. More particularly when 3G6 stipulates that it has to be done as per the Assam Arbitration and Conciliation Act. And in view of 29A, there is a period of 1 year. How will one person complete this? Earlier, at one point of time, acquisition under the National Highway was not much. But with the mammoth of litigations which are coming up every day, something has to be done and the government has to take up the decision immediately. Apart from the fact, but one thing your government also, the central government also have to take note of. Recently, notice has been issued. You see, 3G5, what is you are doing? You are appointing, the union is appointing. On one hand, you are saying that this has to be made in terms with 3G5, 3G6, which means Arbitration and Conciliation Act. Now, as per Arbitration and Conciliation Act, one party cannot appoint. And that issue has then been referred to a larger, notice has been issued 3 days before by the Supreme Court on this, where there is a challenge to section 3G5. There has been a challenge. Notice has been issued on that. Because of the fact that how do you take care of this situation that now you, in view of 12.5, there's a big problem which is being happening because of this. And this will result in a huge problem.
Now, the arbitrator, as per the provisions of 3G5, arbitrator is to be appointed by the central government.
Yes, that is why that section has now been put to challenge and notice has been issued by the Supreme Court.
My lord.
Because on 3G6 says that it has to be as per the Arbitration and Conciliation Act.
Yes.
Now what happens, the problem comes to section 12.5 of the Arbitration and Conciliation Act, which stipulates that there cannot be any interested parties.
Yes.
And one person cannot in view of the Perkins judgment.
Yes.
So how does the central government, who is a beneficiary, is going to appoint?
Yes.
So that is why the issue, the court, the Supreme Court had issued notice on 3G5.
Yes. That is, my lord, the role of the state government is only to, my lord, make a nomination. It is the central government who is to take the call. Of course, as per the statute.
No. State government doesn't have any business out here. But what the central government is doing, the central government is appointing the commissioners as arbitrators on the ground that commissioners are already receiving the money from the state government.
Yes.
And as such, we need not pay the additional amount of the arbitrator.
Yes, that honorarium is, my lord, that they are relieved.
So they are relieved.
They are
That is the
relieved.
basic why the central government is doing it.
Yes.
Now the problem is, which is happening out here, is they have appointed some Ashok Burman, who is the retired person. And the central government, the moment that happens, now the central government has to bear the burden,
Yes.
which the central government is not willing.
So therefore, my lord, as per the act itself, my lord, the central government, for the purpose of appointing the arbitrator, they will have to lay down the parameters. If lordship is correct, my lord, that one person cannot make, they will have to take a call. Because the act itself says, my lord, I am nobody. State government is nobody. So it is the central government who has to take a call. So therefore, my lord, in view of recent amendment of the Arbitration Act, so far as section 12 has been amended, as rightly pointed out by my lord.
Now that is the issue before the Supreme
Yes,
Court.
yes.
Now what is happening, if I bring into that issue out here, it will have a further cascading effect in all the matters.
Yes, all of it.
And who is going to pay the interest on enhanced amount? It will be a huge amount. Every time it is going on, if there is an enhancement, it will go up.
Perhaps, my lord, it may call for some amendment of this, my lord, 3G5, 3G6.
The 3G6 would not be there, but I think they may give it under 3H. They may be amendment. The best option is that you bring 3H. You see, 3H4, whereas you are already giving to the district judge to decide on the apportionment, you give the additional burden of deciding, which is already being decided in all other acquisition proceedings. That is the only way out, I see.
This 3G5 and 3G6 my lord, may have to be deleted. This is, my lord, what I find
Yeah,
as of now.
something has to be done
It
because
has to be deleted and, my lord, and incorporation has to be made in, my lord, 3H4.
Ah.
My lord has rightly put it. Yes.
that is the only way I see.
Because 3G5 says you appoint an arbitrator giving full, my lord, authority to the central government. 6 says, my lord, that subject to the provisions of this act for every arbitration, 96 Act will apply.
Ah.
So 6 is related to procedural part, 5 is related to appointment.
Fair point. Now, 6 arbitration, the moment for that, how can you have it in view of Perkins?
Finally, my lord, we may have to wait like, my lord, that section 24, unless and until, my lord, that dictum has flowed, my lord, in Indo Development Authority. Maybe that kind of situation may
But then the problem will be, there will be litigations right, left and center in the High Court. The High Court can't exercise, has to exercise then.
because in Indo Development Authority, lordship is there, my lord. Supreme Court has put an hold, express hold. And it has issued a, my lord, dictum to all the high courts that this kind of matters put on hold till a final decision is arrived at.
Now,
Similarly,
earlier it was okay, but the moment the district commissioner is gone, the commissioner has been removed.
yes, now it has been abolished. So it
But without going into that aspect, you don't have any role, it's understood. But something there has to be some correlation because you have been also appointed as a competent authority.
Yes.
Now, if there is
competent
that,
authority is also, my lord, appointed by the central government.
understood.
Of course, my lord.
But then also you are being appointed under the 3A notification. You are appointed.
Yes. There.
So something needs to be done for that.
In order to, my lord, ease out the process, my lord, that competent authority Sala is appointed, my lord, the authority is given to the person who is holding the post of additional deputy commissioner revenue in all the districts. What is state of Assam?
No, it's okay. That is different. But now earlier what they were doing, they were giving it to the commission. There's a notification to that.
Yes.
Now that notification has gone for a 6. So they have to issue a notification.
Yes.
So you appoint, do something. Whether they don't do, it's that is the.
So we have only.
But what has happened in the Supreme Court, as I was reading the order and the contents of the writ petition which was being filed in the Supreme Court, interestingly, which is being done in Manipur has happened. Manipur and Tripura, what they are doing, they are appointing the district commissioner.
District commissioners as my lord arbitrator.
Arbitrator. Now that is another issue that you see the district commissioner is otherwise the competent authority.
Yes.
Because in our land and revenue regulations, the district commissioner means the additional. How do you take care of these situations? But something has to be done. The central government, if it doesn't appoint, what is going to happen?
So if there is, they have made a nomination, because that has not been accepted. Not taken off for appointment of architect. Because the act is very clear, the central government. Even then, there is a nomination from the state. That person there. Secondly, that has to be uploaded to the portal page.
No. If they upload anybody, but you have to appoint.
Yes.
You without that issuance of a notification, how can you do that? It is you who have to do it.
Yes.
You may choose somebody, A, B, C, D. You choose anybody.
Lordship will make an observation. That will help.
This court, by the order dated 21/12/2023, had requested Mr. Arkadev Chaudhary, the learned deputy SGI, to apprise this court as to what steps have been taken by the Ministry of Road, Transport and Highway for the purpose of appointment of an arbitrator in terms with Section 3G5 of the National Highways Act 1956. Mr. Arkadev Chaudhary, the learned counsel, submitted that verbally he has been informed that the nomination of Sri Ashok Kumar Burman, IAS, retired, who was the Special Secretary to the Government of Assam, Revenue and Disaster Management Department, for appointment as an arbitrator for the state of Assam for settling of dispute in connection with acquisition cases acquired under the National Highways Act 1956, cannot be acted upon in view of the fact that the said official had retired. So, be that as it may, this court finds it very pertinent to observe that a duty has been conferred upon, duty and an obligation is an obligation. This court finds it very pertinent to observe that an obligation has been cast upon the central government for appointment of an arbitrator in terms with Section 3G5 of the National Highways Act for the purpose of deciding the question pertaining to inadequacy of compensation. This delay in appointing an arbitrator would delay in adjudication of the claims relating to inadequacy of compensation, which in effect would result in imposition, enhancement of the, would result in payment of additional interest if the amount is enhanced. The consequential effect thereupon would also be on the public exchequer. Under such circumstances, this court again fixes the matter on 12th of February 2024, on which date Mr. R.K. Dev Chaudhary, the learned Deputy SGI, shall apprise this court as to what further steps have been taken by the central government for the appointment of an arbitrator. This court, however, also observes that the Revenue and Disaster Management Department shall also aid the central government, if so need be, for the purpose of deciding. Should I put that?
Yes, yes, yes. Otherwise, the statute doesn't cast any responsibility on the state.
What steps have been taken for appointment of the arbitrator? In that regard, the central government may also make appropriate consultation with the revenue department of the state.
Yes, yes, yes.
List the court.
So obliged.
45. Because it will have a big problem.
Yes.
Yes.
No, this is by the petitioners, applicants, madam, who are a group of shopkeepers, madam, sitting on a government strip of land, madam, on the southern side of the MS Road, madam, in Fancy Bazaar. Madam, in this case, madam, what has happened, the respondent is committed to settle the petitioners permanently, madam, and they put this on affidavit also, and that is recorded particularly in order detail 9/8/2021. 9/8/2021.
The matter has not been disposed of.
Not been disposed of, my lord. They have, my lord, I have given a letter at annexure at page 16. At page 16 of the application.
Now, what do you want now? What do you want?
My lord, we want that, my lord, direction be given to the respondent to show this piece of land, which they say that they are proposing or they are going to give us. We have been following up in the office, my lord. Sometimes, my lord, and we have in writing also, we have given on number of occasions. But till date, my lord, they have not taken us to the land, my lord. And on the other hand, my lord, the place where we are sitting, my lord, in the strip of government land between the jail wall and the MS road. Now behind us, they are coming up with a sewage treatment plant, my lord. It's actually called.
But Mr. Goswami, you have not impeded Mr. M. Debo.
Yes, attempts were everything. You must know,
Without impeding him, not his party, him.
It doesn't become.
If I pass an order, he will again come up another petition to the effect that I am being affected.
So his interests are more towards my lord, the center, my lord, the hub of the festival. These are outcomes.
So,
my lord, once they come make up the road, my lord, then my lord, soft will have to be
we
brought
do
down.
one thing, we'll issue notice on this application. You get your instructions and price. I only IA 157 of the issue notice making it returnable on how long? 7th of February. 7th of February 2006. Mr. Ezora appears on behalf of the respondent number 1 also.
Yes.
It is GTD.
No,
You
GTD
appear.
is the same.
Appears on behalf of the respondent number 1, 3, 4, 5, 6, 7, 8.
No, 8, my lord, I
Uh,
don't think notices.
Why you are making these people
all
party?
name, all by
My
name. These are because they were parties in the writ petition actually, possibly.
Their
that is
names
why
should be struck off. Unnecessarily, you have made people party.
No, in the writ petition, my lord, from
Okay,
here,
okay.
my lord, I think we can
Appears
strike
on
off.
behalf of the and Mrs. M. Gorman appears on behalf of the respondent number 2. So this court is not inclined to issue notice upon the respondent number 8 to 11
Right.
of the instant application. Mr. Ezora appearing on behalf of the respondent shall apprise this court as to whether the petitioner representation. Have you submitted representation?
Yeah, my lord, yes. Well,
As to whether the petitioner's representation have been considered by the respondent DMC authority, and what is the status as regards the state representation?
Typographical error, my lord. It is not.
Cause title means where do you want to change?
So, my lord,
Name of the parties you can't, huh?
not the name of the party.
Where?
So, my lord, in the that one, my lord, I have noticed, my lord, the department was DDD was not.
No, did you put it out there?
Yeah.
You see, the problem nowadays appears out there is if you do it by hand, it will never come up unless you file a proper mandate.
That was the notification.
Eta line like the PT Goswami, the learned counsel, hearing on behalf of the applicant submit that there are certain errors in the post title of the post title mentioning the names of the party for which he may be permitted to correct the same. So this court is of the opinion that he may be, this court grants liberty to the direct the petition that permits such correction by filing and by submitting an amended memo of parties before the registry of this court by 25th of January 2024, and thereupon on the basis of the amended cost title profile, amended memo of parties profile, the registry shall make necessary correction and also upload the same in the.
Maybe that
You have already the name.
Yes.
You just put it GDD. What is the problem? You are just to print out the same, making the correction. Because if you don't give it by
Yes,
hand, if
that
you
will
put
formalize
it,
it.
you will have a big problem later.
GOP notice.
Ah, yes. It is early.
Wait, please, your lordship. The all petitioners are my lord, but are my lord, and my lord, their land was acquired by the authority in deputy commissioner, but without any my lord giving a notice my lord or a newspaper my lord, local newspaper. And we have understand that our land was acquired under national highway.
So award has been passed by the arbitrator.
No matter. They only given only 70,000 per visa.
What is your prayer, page 20? A
Page
writ in the
20,
nature of mandamus should not be issued directing the respondent to redetermine, reassess the amount of compensation for acquisition of land of the petitioner in terms with the final award dated passed by the arbitrator.
That similar same area by the other land was passed by the arbitrator. Then my love, we are not in the arbitrator because of that arbitrator is given entire area, right? But our land was not attained. But our money was our money.
How can this court enhance it?
My lord,
How can this court apply? You see, the principles which you are asking for applying is in terms with section 28A of the Land Acquisition Act 1894. But that also, the judgment has to be that you have to move before the arbitrator, file an application before the competent authority for referring it to the arbitrator.
Yes, but what is that? But they did not do it, right?
Did he apply before the competent
No, we
authority
filed a petition to the competent authority.
for referring it to the arbitrator?
Not for enhancement, for petition for enhancement.
Has to be referred to.
But one thing is that after filing this petition, they filed an application. They stated that it's not under the national highway. They stated, my lord.
Then how did the arbitrator decide?
Yes, my lord. Now, my lord, they stated that this is the Land Acquisition Act 1990. They had to pass
1894.
90.
1894, then how can you get any award on the basis of the arbitrator?
No, my lord. They did not any, because of that initial for acquisition of land, they have to publish the notification as well as the newspaper, local, and it is the mandatory. But they did not do it. And
So there is no section 4 or section 6?
Yes, sir. 6(1) is not complied with as per 86 of. Yes, my lord. This is kindly, ma'am. There are 5 my lord. Page 77 now. Page 77. That with regard to the environment made in paragraph 5 of the restriction different states that the same are not correct. It is stated land measuring 35 figure 3 katha 9 lista has been acquired for construction of railway overbridge to BC standard connection with Rangya North Lakhimpur conversion project as per provision of Acquisition Act 1994. Accordingly, notification under section 6(1) of the State Act was duly published in Assam Gazette and given wide publicity in newspaper, namely Assam.
Yes, madam. Annexure to 83. Please, it-
As per
Madam, you being on record,
My lord, that is.
bring the record.
as per my lord,
Because you have to, let's see whether you have done under 4 and 6.
83.
And if it is done under 4 and 6, then obviously the right of filing an appeal, appeal is gone. It's important to have to move and
Page 83, my lord. In the Assam Tribune, my lord, we have published.
produce the record of the land acquisition.
Lord.
That is the only way as to whether you have done as per 4 or 6. You have to do a 4, then
Hello.
6,
6.
and then 11,
6 to
and 12 is 5.
Six
Period
one
is
we
like
have-
this: 4,
Right.
then 6 is 1 year,
Right.
then 2 years, 11.
and my lord, they have to publish in local daily newspaper, my lord.
Yes,
2
Assam
papers.
Tribune.
One, my lord, national paper, and one is mandatory.
Assam
section-
Tribune, ma-
No, no, first of all, it is a matter of 2018.
My lord.
When did you, the award was passed when?
That award is in another similar situated land, my lord.
2021.
No,
Award was passed in 2018.
18.
That Why are you challenging 2021?
What?
Are you challenging the acquisition proceedings?
We are not equipped for sitting.
You are not challenging the acquisition proceedings. You are saying and this is done under this notification.
Coming on enhancement, we are don't know by the then paragraph 5 of the petition by the
No, here
by the
the short description of this 3A land of
Right.
2014 which we are referring to.
Right.
Does it include your land? Page 23 and 24 of the writ petition.
no madam.
Page 25 of your writ petition.
We are no only page 25. Page 25 of my read petition. Only
Yes.
they are giving us a statement of respect of
Where is your name?
name tail number 1, my
No. Huh?
tail number 1, page 25. They did not provide any notification.
Where?
Page 25. Our name is tail number 1.
Tail number 1 is some Golok Kurmi.
Yes, yes, petition number 6, my.
Huh?
Yes, okay. Petitioner number 7, tail number 1.
This
Petition
is
number,
some son of Benudhar Kurmi.
yes. The petition number 7 and petition number 2
Okay.
is tail number
Now,
5.
no. First of all, why your name is not there?
Our name is there. Parent of tail number 10. Okay, so Teka. Tail number 10.
Okay, so Teka. Now, this is the 5. This is the notification under what?
Not only they provide us for acquisition of concern statement in respect of land acquisition case number 21 for the case. Now, after
First of all, you have received the money.
only 70,000 per bigha we are making. We are
Understood,
coming
but
on
this
for
is done
enhancement.
under statement of LA case number 21 for construction of railway overbridge.
Right.
Yes.
Is it your land they use for railway overbridge?
Yes, right. They set as the railway overbridge, but our land is not national highway in road to
So
our
this is for railway overbridge.
Yes. No,
Then how's your land involved?
Yes, it acquired by the deputy commissioner.
Deputy Commissioner may acquire for many purposes.
Well, as per their affidavit stated.
Hello,
Now I am know that our land is
Page 83, Malat, the form Malat under form 7, Malat, for the declaration under section 6, Malat. There we have stated in the Malat, in the local news. We have
Where is
published it in local newspaper. Assam Tribune.
Construction of the existing ROB to BG standard in connection with Rongia North Lakhimpur conversion project declared for the above purpose measuring 35 bighas 2 kathas so and so. This is under section 4. Section 6.
89.
that was not my lot.
No, wait. What is this again? Where is the original of this? Page annexure B. Where is the original?
Page 32.
Huh?
Page 30.
No, I don't understand one thing. How can there be, this is by Deputy Commissioner Punitpur and this is by Deputy Commissioner Punitpur. How can there be two LA case 21/2010? And this, what is the date of this communication? This is of 2014.
There are so many details, but they are only provide this. They did not any notification, did not. Now we are known only after filing this affidavit. No point. Everything is by reply. They only stated in affidavit that Assam Tribune they were published in 1/6/2012. But
Yes.
there is no any local newspaper, but as per provision of 6.2 specifically mentioned that. We have no knowledge about that fact. And this, there is no mention in our name also. Name is not Pastor number, tag number.
What to do, Mr. Borbadari?
Maybe please to call for the record because the authorities have
I don't understand.
So they have
They have one LA case. Normally, you can have only one LA case for one number of one district.
Yes.
This district, LA case number 21/2010,
My lord.
has been shown as construction of existing ROB to BG standard in connection with Rongia North Lakhimpur conversion project. Okay,
Yes, sir.
so this is that. On the other hand, LA 20, this is done under the 1894 Act.
1894 Act.
Now, if we see this LA,
It starts from page 25 onward in the writ petition.
yeah,
In the writ petition, my lord, maybe please to come to
page,
page
kindly come to page 32.
page 32.
This is LA case statement in respect of LA case number Iman acquisition for construction of railway overbridge at village Marudani Moja Bagmari.
Yes,
This is completely different.
No,
And this is also been done by Deputy Commissioner.
No, this is the same. Page 32, Lordship will see.
Ah.
Page 25 is the type copy.
Okay, page 32.
So page 32 also it says, my lord, is a statement in respect of LA case number 21 of acquisition for construction of railway overbridge. Railway overbridge
At village
at
Marudani Moja Bagmari.
Moja Bagmari. So this
Okay,
is
now kindly come to page 81.
page 81.
Yes.
Page 81. Page 81. Okay. Yes, page 81, it appears the government of the land is required to be taken by for publication. Construction of existing ROB, railway overbridge to BG standard in connection with Rongia North Lakhimpur conversion project.
Hmm.
Same matter.
So it is done under that.
Yes.
So this document has what relevance? This Adirokon. This is a different land.
Which one, my lord?
Page 23.
Page 23.
So this land is different.
This land is different. This is with regard to
Mr. Bora, this land
This is with
happens to
highway.
be the land from that from Koliabor onwards. You see, 37A is the national highway to Koliabor.
Yes.
But your land, other railway bridge is not there.
That is now is after filing the 3 months before we know that after filing affidavit, this land was as per LA 21.
No, understood. So this land, this notification has no relevance.
No relevance. No relevance.
No, because this is 37A, which is
Yes.
the Koliabor,
Yes, we are
which has
using a-
nothing to do with this one,
Yes.
because this is the main highway land by which it goes to Gopur.
Yes, their officers are authority are regularly saying that on the basis of we were acquired. So thereby we are regularly represented. But after filing this petition, they annex this document by affidavit. Thereby this problem is happening. We cannot know whether.
Anyway, okay, list the matter again on 9th of February 2024, on which date Mrs. U. The learned additional senior government advocate shall produce the records of LA case number 21/2010.
Yes, my lord. Yes.
Because if it is done under this provision,
Yes.
then the question does not arise.
Yes.
Yes, my lord, this 14, my lord, this 14 from
But
notification
if this section 6.2 is not complied with, there must be
You are not challenging that. Why should I take note of that?
because of that we have no knowledge about that matter.
You
That
don't
is not-
you
that
don't
matter.
have knowledge. That is
No,
your
no,
thing.
no,
If
they
it
have
is
to
given in
find
the
a regional pilot, newspaper,
I
my
can't
lord.
help
If
you.
regional newspaper is violated this, my lord, entire proceeding is wrong, my lord.
You can't challenge now.
Problem is that we have filed a representation, that will reference to be made to the district judge, my lord. We have to keep the opportunity. Otherwise, all nearby, so all are receiving in 7 lakh. We are receiving only 70,000. Deprived, all are.
You did not see that your nearby neighbor had become rich overnight and you are still poor.
Yes, definitely.
Then
So, my lord, the problem is that, my lord, they have to knowledge.
Yeah.
Technical problems are there on.
Yeah, my lord, but- my lord,
Four people, my lord, that we understand, but what?
the enhancement for
Citizen-
enhancement regarding only for pair for enhancement.
enhancement to can't be done here.
Yeah.
No, my
The
lord,
enhancement
to the
has to be
reference, my lord,
moved.
to the
Reference
that
has
is
to
pair
be made.
before.
That
Deeply obliged.